Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1264 et al. Sunflower Electric Power Corporation petitioner versus Federal Energy Regulatory Commission. Ms. Murphy for the petitioners, Ms. Benta for the respondents, Ms. Taylor for the interveners.
Good morning, Ms. Murphy. You may proceed when you're ready.
Thank you, Your Honor, and may it please the court, Erin Murphy, on behalf of the petitioners. The SPP tariff amendment at issue here was proposed to address a serious cost causation problem in parts of the region owing to certain wind-rich zones. FERC recognized as much in its first set of orders addressing that amendment, where it expressly encouraged SPP's efforts to remedy the cost causation problem and ultimately accepted the amendment, subject to 2 minor tweaks, that it found would fully address any lingering concerns about the scope of the SPP board's discretion to approve alternative cost allocations for certain transmission facilities. Yet 9 months later, FERC completely reversed course. Though nothing had changed in the interim save the commission's composition, a newly constituted FERC now concluded that the very same amendment that it had just found fully addressed any concerns about discretion and transparency somehow no longer did. That about-face can't be reconciled with the FPA or with the APA. Under the FPA, FERC is required to address cost causation problems that it identifies, not sweep them under the rug, let alone reinstate them shortly after having accepted an effort to correct them. And under the APA, FERC has an obligation to adequately explain itself when it abandons earlier findings made on the exact same record and departs from its own precedent to boot. Yet FERC didn't even acknowledge its earlier express findings that the tariff amendment no longer posed any discretion and transparency concerns, and its efforts to distinguish past orders that approved exercises of far greater discretion with far less transparency by the SPP board are so flimsy as to border on pretextual. In short, FERC's orders smack of a result in search of a reason and can't be sustained.
Why should we hear this case given that your client essentially got all the relief they could ever want and even more relief than they can get in this case in your other proceeding, the waiver application?
So for 2 reasons. First, in the waiver application, while that proceeding is now final before FERC, it's very much still a matter of live dispute because the same parties that are here as respondent interveners defending FERC's rejection of this tariff amendment have already filed petitions for review with this court challenging those proceedings and those orders before FERC. So we have a live dispute that still is ongoing in the courts, which is enough to dispel any concerns about mootness. But second, and more broadly—
What's your best case on that?
I think the court's recent Norfolk Railway case deals with another dynamic where a case was still pending in there was litigation still pending, and the court said it didn't matter whether it's likely or unlikely what the result in that litigation will be. It's enough that there was still litigation pending, so the dispute was still live. And you know, don't get me wrong, we certainly think that FERC's orders were absolutely correct, and we fully intend to defend them before this court, but there is absolutely still a live dispute before this court about those proceedings. But even beyond that, you know, what's different about those proceedings and this proceeding is actually those proceedings concern only a particular set of existing facilities and whether their costs should be reallocated. What's different about this proceeding is what the stakeholders were all trying to do here is come up with a tariff amendment that would create a going forward fix so that when we have new facilities that come online or upgrades to existing facilities in regions that satisfy, in the zones that satisfy this criteria, you could allocate their costs this way from the start rather than having to deal with this as an after the fact issue or go through a complete set of FERC proceedings to deal with it, you know, as each and every facility comes online. So
I'm sorry, I didn't mean to interrupt.
No.
I have a sort of a basic question, which is the costs that we're talking about here. These are the costs of constructing the transmission infrastructure, or?
I mean, the costs basically then get spread over the lifetime of the transmission facility.
Okay, so they're costs of constructing that are amortized.
Constructing and you know, there's
maintaining.
some, exactly.
Not
So
like a cost of the actual transmission of the power, which is
It's essentially, that's why it's cost allocation is the concept of taking the costs that you kind of know will
Yeah.
exist from the facilities and figuring out how they should be allocated among the region, which I think actually, goes to why there's really not a serious argument about standing here, because what the petitioners are here and the respondents are here, we're all members of SPP who pay these costs. And so we all have a profound interest in what the allocation of the costs will be, both for existing facilities and as future facilities come online.
Well, the question is, what future facilities? I mean, what imminent harm is there?
Sure.
It seems a little vague in the factual presentation that we've gotten, and the other petitioner, SPP, doesn't identify any future facilities in their papers or in their briefs.
Yeah, and I think it's fair to say that at the moment of these orders and this briefing, there weren't particular new facilities that had been planned to come online, but SPP plans on kind of a rolling basis. So you have new facilities come online. Pretty much at any given year, they're going to be approving new facilities. It's my understanding they're actually, this isn't in the record because it's more recent, but proving the point that we expect there to be future facilities. There already is at least one facility planned in the Midwest region that could be a candidate for this kind of waiver. So, I think the reason we're still here and the reason the respondent interveners are still here is everybody recognizes that there's going to be future transmission needs, particularly in the zones that satisfy the first criteria here that SPP would have set up, because the whole reason we have this dynamic, this cost allocation problem, is because there's a very high volume of generation going on in these zones, this significant substantial increase in wind generation over the past decade that's continuing to increase. And as you have more generation come online, you're going to need more transmission, you're going to need upgrades to existing facilities, and the facilities in these regions are predominantly byway facilities, which are the kinds of facilities at issue in the transmission in the proposed tariff amendment.
Assume that what you said about possible future facilities coming online and being eligible for this, it would be enough to defeat mootness. Would love to hear why, as a practical matter, you're opposing abeyance, which would allow us to consider this case along with the other. And as you know, the rehearing order has already issued. It seems like it would probably be a delay of about another year, and it would allow the court to have all of these related issues before it. And it does seem, at least to my understanding, hard for you to say there's likely to be another facility in the next year that you're actually going to miss out on being able to pursue this for. Could you respond to that?
Yeah, so I think, from our perspective, this case is fully briefed, and this case is actually kind of broader than the other case. The issues are a little distinct, and this one is broader in that it deals with a fix for the whole SPP region. And so if anything, it makes more sense to be considering this case first, because we wouldn't have ever even needed the other case and gotten to those orders if this tariff amendment had gone into place. We would have just gone through the tariff amendment process rather than SPP needing to file a separate 205 for those particular facilities. So if anything, the order seems right to sort of start with the question of, okay, is this something that SPP can fix on a region-wide basis? Can it have an amendment here that allows for cost allocation consistent with the ex-ante principle that the other side's bringing up here? SPP is trying to do something consistent with that and say, let's put something in the tariff that tells everybody what the rules of the road are going to be as new facilities come online. And it's important for planning purposes to know that. Everybody would rather know at the front end what it's going to look like. So I think it really does serve those principles and those planning, that whole.
But even if you prevail in this case, that only gives you an opportunity to essentially apply for a waiver. You don't necessarily get it. You might, maybe, the odds are that you will, but if it's denied, then you'd be challenging and you'd be back here challenging that, presumably.
Certainly.
Whereas for these 4 facilities, you've been granted. That was the whole purpose of that process. And the papers talk about an upcoming facility that's unaffiliated, which I presume means that it's not yours. What is unaffiliated?
So I don't think there's any, I mean, we haven't, at the time of the briefing, we were not arguing that there's any particular facility that's coming online for either of petitioners that would be beyond the 4 that are already dealt with in the separate proceeding that would be subject to seeking one of these waivers. But we absolutely do expect there to be facilities in both regions. And this was, there was evidence about this before FERC about this. If you look at JA 122 through 25, JA 137, 38, there were declarations from both Midwest and Sunflower explaining why they expect there to be future facilities in the very near term that would satisfy this criteria. And so, you know, you're right that it's a right to apply for a waiver. We're not guaranteed to get one, but with the extremely narrow discretion that now exists under the amended version of this tariff amendment, it's pretty clear, you know, you'll be able to figure out if you satisfy the criteria. I mean, if you just take the example of what happened during the 9 months that this tariff amendment actually was in place, only 4 facilities applied. The Sunflower facilities are the only ones who applied. And if you wanted a reallocation, you had to apply during that period because there was a 180-day clock running once the tariff amendment went into place. And so, you know, once people had a chance to have this in place and look at the criteria and figure it out, there wasn't this enormous universe. There's more than 1,200 facilities in the SPP region, and only 4 of them thought they could satisfy this criteria. And as you could see from those separate orders, they satisfied it kind of running away. It wasn't even a close question. And so given the way the tariff amendment works, after the specific requests that FERC made to modify it, it says that SPP's board, the only thing it can base this decision on is whether the 3 criteria are satisfied. So if they're satisfied, you're getting a waiver. And if they're not, you're not. And if you don't get one and they are satisfied, you're gonna have a very powerful 206 application to FERC saying that the board didn't comply with the terms of the tariff.
I was on the jurisdictional questions. I understand you don't represent SPP, but do you think there's an argument that SPP is differently situated? I mean, it seems like they are the direct object of this order, and in a practical sense, we're reviewing an order that removed an authority from SPP.
Absolutely. I think that SPP has standing independent of petitioners here, and that of course is sufficient basis for this court to resolve this case if you had any doubt about petitioners, because of course SPP has an interest in its authority under its own tariff. It is, as you say, the object. I mean, it's the object of FERC's action, then we are the objects in the sense of how the tariff operates because we're the members of SPP who are going to pay the costs under the cost allocation. So if you know, neither SPP nor its members have interest in how it allocates cost, I'm not really sure how this court's ever supposed to be reviewing determinations about what the terms of an RTO or ISO's tariff are. And really, if you look at cases that have raised standing concerns, they haven't been in the context of people challenging or defending amendments to the tariff that applies throughout the region. They've been in the context of more specific, you know, things that only affected one facility, or in the context of things where you didn't have final agency action, dynamics like that. This court has long reviewed cases where the members of the region and the RTO or the ISO are the parties who are here defending the tariff or the challenges to the tariff, or you know, attacking the
But in
challenges.
looking at those cases, it seems like the RTOs that have standing, they can point to not just that they were the object of the regulation, but that there would be some cost that they would incur due to the regulation.
Well, usually the cost is actually going to be borne by the members because the RTO or the ISO is just kind of setting the rules of the road about how the costs throughout the region are going to be allocated among the members. So in the petitioners, my clients are absolutely facing the costs because
that's then passed on to the ratepayers.
that's right. Yeah. Right. So ultimately, you know, all of this is about who's going to, you've got the entity who wants to be able to make the decisions about who can pay the costs. And then you've got the parties who actually have to pay the costs. So between us, we've basically got the universe of interested parties in this amendment. And if you can't kind of challenge this now, there's no way to do it, because if you have to wait till you have particular facility, sure, we could have, you know, try and get SPP to file a separate 205, but we're not going to be able to challenge what happened in these orders, which is the denial of SPP's effort to amend its tariff.
Why is this cost allocation issue not better addressed through the RCAR process.
Yeah, FERC itself rejected that argument in the approval order, and it never resuscitated it in the reversal and rehearing orders. So I don't think it's actually, I think there's kind of a Chenery problem with respondent interveners making that argument. But as FERC,
So this is not the same as the ex ante.
there's separate
point of
issues.
it.
Yeah. So the RCAR, I mean, FERC explained this a lot more in the separate 205 proceedings where it's a little bit more at issue. And as in that rehearing order they submitted to the court a couple of weeks ago, it talks at a little more length about the RCAR and how it's a different process. It's not designed. It's at a higher level. It's at a zonal level rather than a facility level. It's done at a kind of a point in time. And so it's just not designed to deal with figuring out whether you have specific transmission facilities as to whom the costs that are being allocated face a cost causation problem. And so this argument, respondents have pressed this argument all throughout the proceedings, and FERC consistently rejected it. It's not one of the two narrow grounds that FERC offered in its reversal and rehearing orders for rejecting this. Now, FERC did reference the ex ante issue in its orders, and I don't think that works for a couple of reasons. First, there's no ex ante issue at all as to the going forward tariff amendment. The whole point of this is to, consistent with the ex ante principle, say, let's change the rules now before new facilities come online. That's what ex ante is all about. And so to the extent there's any ex ante.
So this is a little unclear to me, but ex ante could be before the construction of any new transmission, or it could be at the time of the overall regional planning process.
Yeah, so.
And I take it you're arguing the former, and that otherwise you can't have a tariff.
Right. Basically, I mean, you have ex ante, the concept that order number 1000 back in the day when it said you should have this was getting at is, let's set rules of the road now that will govern kind of all facilities as they come online. So people know the rules as they're thinking about transmission planning for the region. And so what the principle is basically saying is have the rules of the road in place before facilities are coming online. So to the extent what this amendment's doing is dealing with those future facilities, it far from posing an ex ante problem.
So what about the existing facilities?
Now the question is, as the existing facilities, and what FERC has explained here and also separately in the 205 proceedings is ex ante. I mean, it's not a rule that says you can never change the allocation of existing facilities. And as FERC put it in the rehearing order that it submitted just a few weeks in the separate proceedings, it couldn't be a rule that says you can never change the reallocation, because then the ex ante principle would be in conflict with FERC's mandate under the FPA that if rates are not just and reasonable on a forward-looking basis, it needs to change them. And so we're not talking here about any retroactive changes. Nobody's trying to reallocate costs that were already paid to change anything that has already happened. This is just a question for those existing facilities of whether the remaining costs that haven't been paid yet should be allocated differently.
I think FERC would say that they were making a little bit of a softer point in their order, which was an aspect of the discretion that would be afforded here is it's both large in scope and it's at least in tension with the ex ante principle to the extent it would allow an RTO to have the discretion to change the rules of the road for an existing facility. And to that extent, maybe you would say that's not sufficient, but is that at least not coherent on its face?
I mean, I suppose that's probably the best understanding of what they're trying to say. For one, it makes absolutely no sense as to the forward-looking issue. It just doesn't, because at that point you're saying we'd rather not have the tariff reflect what we're going to do, and we're going to deal with this in a one-off situation, which is contrary to it. As to the existing facilities, I think it's not consistent with FERC's approach generally to all this, and it's not consistent with the approach FERC took now in the separate proceedings, where it said this isn't some hard and fast rule. I mean, if ex ante meant you could never change the allocation at all, never have any reallocation, the ex ante principle would be even more aggressive than the filed rate doctrine, because you're allowed to change on a going forward basis rates under the filed rate doctrine.
Well, and FERC approved the allocation with respect to the only ones that are, as you say, arguably
Exactly.
ex ante. So
Exactly. And it dealt squarely with this in those separate orders and said, this isn't a problem because ex ante is not a hard and fast rule that says you can never change allocations going forward. And it specifically said, which I think is absolutely right, that to the extent you were to interpret ex ante that way, that principle, which is just a planning principle in a FERC order, would be essentially overriding the mandate of the FPA that you can't, you have to change rates when they're not just and reasonable and when they pose a cost causation problem. So I don't think there's any, I just don't think the ex ante argument really gets them anywhere. And the two.
Can I ask about one of FERC's other rationales, which is the benefit criterion allowing two different metrics rationale? FERC doesn't make that argument, but the interveners do.
Yep.
And I'm wondering, apart from the fact that FERC changed course, what is your argument that the possibility that multiple metrics would be used couldn't lead to discriminatory results?
The problem with that argument is there's nothing discriminatory about either of those options. They're both, as FERC said in the approval order, they're just two metrics that FERC itself has recognized are permissible ways to demonstrate what kind of the costs and benefits throughout the region are. And so
but it does raise the possibility that two otherwise similarly situated applicants would have different results if the metrics pointed in different directions, doesn't it?
Well, I mean, the metrics, I'm not sure there's going to be a situation where the metrics kind of point in like completely different directions. I mean, essentially what seems to be contemplated is, look, you can put forward one or you can put forward two. I suppose somebody who's opposing it might try to say you put forward this one because you don't satisfy that one. But I think the point that SPP was making in the tariff is, look, these are two metrics that FERC itself has repeatedly accepted as permissible metrics for figuring out if, allocations are consistent with cost causation principles. And so accepting the same metrics and saying either one of them is going to get you to the same place just doesn't seem to be the kind of thing that sure, I suppose you could say like there's discrimination in some sense, but as this court has put it, the FPA requires undue discrimination. So you'd need to be treating entities differently that are really like completely differently situated, not just it's a little easier for us to show it under this metric versus that metric, but they both show the same thing.
One of the difficulties for me on this specific issue is that nobody seems to explain whether these metrics are ever going to lead to different results. FERC seems to assume they will. Your side seems to assume they won't. And one view would be we hold that against FERC for not explaining further, but another would be we hold it against you for not explaining why FERC is wrong.
And I suppose you anticipated what I was going to say, which is I would urge you to take the first path, which is that if FERC thinks that's a problem, it needed to explain it. All it did is say there's two different metrics, and so therefore that's a reason to reject it. I don't think that's sufficient. FERC has an obligation to explain why using two metrics that are FERC approved, metrics FERC itself has used in the past is somehow going to pose some big problem. The mere fact that you can look at two things, I mean, that in itself can't be the reason for rejecting. And it's also completely inconsistent with how FERC has operated when it comes to other terms of SPP's tariff that allow for the exercise of discretion. Because if you look at both the base upgrade plan waiver process, the transmission waiver process, the two that we talk about in the briefing, I mean, those don't even require, they don't limit the criteria the board can consider at all, because they explicitly say they can consider what's in the tariff, including but not limited to what's in the tariff. So for FERC to say, you've got this, you've set up this process that actually is way more constraining, but we somehow have a problem with you saying that you can prove it two ways, when in the past they've said, we don't have a problem with like any way you want to try to prove that you're entitled. I think they run into lack of reasoned explanation and a departure from their own past precedent.
So I am struggling a little bit with I think the same thing that Judge Garcia is struggling with, which is sort of bringing this down to a more concrete level. So if there were two identically situated facilities and they both thought, okay, for us, the benefit, we're going to show that the first of the two benefit criteria, that's the showing that they make.
Mm-hmm.
And they don't turn to the integrated market criterion. So what if FERC says, okay, facility A has met that. Facility B, we're going to consider facility B only whether it's met the integrated market criterion. Is that possible? If not, why not?
I think that would violate the terms of the tariff amendment, as I understand the tariff amendment, because the tariff amendment says the board has to, the only thing it can look at is whether the three criteria are satisfied. And the amendment specifically says, as to the third, the benefit criteria, that you can satisfy it through either path. Only those two paths, but through either path. And so if SPP's board has an application before it that satisfies the first criteria, the second criteria, and one of the two ways of satisfying the third criteria, I don't think it has discretion to say, well, we're going to make you prove it the other way, because the tariff amendment specifically says that either one is sufficient. And so I think it makes clear, that all you have is just two different ways of trying to prove the same thing. And owing to all the transparency that's built into this process leading up to the board's vote, you're going to have a very complete record to understand what the board was looking at, what evidence it had, whether it had a good basis to conclude that the criteria was satisfied. So I think all that goes back to why the discretion concerns for FERC just really aren't grounded in reality, since the tariff amendment explicitly says that the only thing that the board can base its decision on is whether the criteria are satisfied. So if the board's doing anything else, it's violating the criteria, and somebody can file a 206 application and challenge that.
I want to make sure I understand your position on the cost causation problem in 206. So am I right? You're not disputing that generally FERC, its decisions whether to sua sponte initiate a 206 proceeding are unreviewable?
Yeah.
General matter. Instead, you think there's something in this record that is sort of an affirmative finding that the existing method is unjust and unreasonable, and that triggers the 206 obligation.
I think it's fair to say it's a product of the kind of unique procedural history of this, that you have FERC having made a finding in the approval order, an explicit finding at JA 326, paragraph 48, where they say that SPP's proposal will better align the allocation of costs here, that this is the better way to do it.
And you think that's
And
the tantamount to an affirmative finding?
I think it's and I mean, FERC has certainly not taken issue with the proposition that the rates that would be produced under the waiver are just and reasonable. I take them to be conceding that, and to really only be arguing about a risk of undue discrimination. And I think when you look at that, that history of them having acknowledged, encouraged, said, we get it, there's an issue here, you need to address this issue, to then at the end of the day just kind of throw up their hands. I mean, even just as a procedural matter, it seems like there needs to be more explanation as to why, after encouraging this very lengthy stakeholder process, they just kind of say, too bad. And I find it, the notion that you end up in the rehearing order with one of the commissioners writing separately to say, why don't you consider a stakeholder process? I mean, my goodness, there was a 6-year stakeholder process. Like that's what this was all about. So under the circumstances of this case, I think that what FERC had to offer about 206 just isn't enough to explain why they didn't take
the
action.
cost causation principle is, it's helpful to your clients here, but it's not, it's a rough, and it has to be a rough principle. There's a lot of, cost sharing to people who are not enjoying the precise benefits that the cost they're paying go to. And, that's just the nature of an energy system.
That's absolutely right. But we're not talking here about a cost causation issue at the margins. The evidence before FERC was that ratepayers in the Sunflower and Midwest zones are paying as much as 2 to even more than 3 times more than ratepayers on average are paying in other zones in SPP.
Do we know how much of the additional expense? I saw your brief, your blue brief, you say Midwest Energy and Sunflower customers face 2022 byway costs of $814 and $1,430 per megawatt month, respectively, compared with a load-weighted average of $427 for other SPP zones. Page 12 of your blue brief. Do we know how much of the additional expense is due to the fact that facilities in these zones transmit wind energy regionally?
Well, I think that's basically what the criteria that SPP established were designed to kind of ferret out. So what they do is they start by saying, first, you need to show that you have a way higher volume of generation in the zone than the zone itself uses, than is needed to serve local load. It's like 100% higher than the previous year's needs. So that's where you start, by identifying zones that have just a high volume of generation that is serving the rest of the region. And then the second criteria, the flow criteria, looks at it at the facility level and looks at it about what's actually flowing over the transmission lines and asks, is there a high volume there of transmission of energy that is coming from that unaffiliated load within the zone, from the load that's not serving the local load, but is instead, independent wind generation, whatever it may be. And so those two criteria are designed to say, okay, look, basically what the stakeholder process was about was saying, we know these costs are higher, let's figure out why, and let's figure out in what circumstances we need to address that problem. And so those two really narrow it down. And once you take those two criteria, you have narrowed it down a ton. There's only 3 zones out of 18 that satisfy the first criteria, and 2 of those are Sunflower and Midwest. Once you get to the second criteria, you're down to 36 facilities of existing facilities out of more than 1,200. And then when you get to the third criteria, of those 36, only 4 sought a waiver. So it's because the way these criteria work is to say, let's not just assume, everything in that zone is incorrectly allocated. Let's find the facilities that actually seem to be serving a much more regional purpose and reallocate costs as to those. And just to be clear, even when with the reallocation we're talking about, which is to reallocate their costs 100% regionally, that doesn't mean Sunflower and Midwest customers pay nothing for those facilities. They're part of the region, so they just pay a regional cost allocation instead of having to bear the brunt, the 2/3 cost that they currently do under the byway system.
Are there other facilities other than Sunflower Midwest who could have but didn't make the application, similarly situated, that just didn't have the brainstorm and would be closed out? Or there's a window for existing facilities, and then, as you say, there's going forward, any new facilities can benefit.
Yeah. I think as to the existing facilities, kind of the logical inference and the inference that's consistent with my discussions with folks about this, there's nothing directly in the record about this, but is that they just determined they couldn't satisfy the third criteria, or maybe there's a handful where they just had very little life left on the project or something like that. But more likely, I think there were just some, the third criteria is a separate criteria, and each of these criteria kind of winnows it down a little bit more. And so they just were determinations that even if the first 2 were met, they couldn't satisfy the third one. And I do think that goes to show this notion that, on a going forward basis, you're going to have some explosion of facilities that are applying for these waivers and qualifying for these waivers. It's not consistent with the record evidence. But I would note that, to the extent there really is some concern that there'd be a lot of facilities, that's hardly a reason to reject the amendment. If you think there's a substantial number of facilities whose costs are not really being allocated consistent with their benefits, that wouldn't be a reason to say, let's leave it alone. Because, if anything, that'd be a reason to say maybe we need a broader solution. But I think the stakeholder process revealed this isn't it's not a problem with the highway byway on a whole, such that the whole thing needs to be reconsidered or thrown out. It's just a small problem that is serious where it occurs, but isn't, it's a small number of facilities, and that's why SPP came up with what it called a surgical response to all of this.
Speaking of the highway byway system, this is another sort of basic facty question. Why is it that producing excess wind power doesn't require high voltage, whereas producing excess power in more traditional ways does?
It's actually more just in nature that these zones where it's occurring, they had pre-existing transmission before they became these very big sources of wind generation, and the pre-existing systems there are byway systems because they're not huge zones. And so you tend to work with what's already there. And so you're going to have upgrades to byway facilities. Your connections are going to be to byway facilities. So it's more just a matter of that was the existing infrastructure in the particular zones that ended up kind of unanticipatedly being these very high wind ridge zones. Now, I suppose.
If you were to start from the beginning and you were building a place where there's a lot of excess wind generation, would that be a place where typically there would be some highway?
I might think my sense is that seems like it might make sense, but it's probably all going to depend on a lot more than just that, because you got to look at the nature of the area, the grid, all of those things. But, to the extent in the future there were a determination that you needed some highway facilities in these zones, then this whole thing drops out because the highway facilities are already allocated regionally.
I think I know the answer, but who determines where and whether to build additional wind power?
So the generation is not determined. That is determined by generators and under state policies and all of that. So we, as the transmission owners, have basically no, we're not deciding what generation is going to be there. We're agnostic as to what's there. It's not kind of our doing that there's a bunch of wind there. It just happens to be there, and we have the transmission facilities, and so we're stuck paying for it.
And who determines where and when to build new transmission facilities?
So the transmission planning, that's where SPP is much more involved in determining what the needs, as long as you're talking about things that are part of the grid. So it's going to be, and that's why we can't kind of just like tell the court, oh, we're going to build some new transmission. We don't get to decide. That is a planning process working with SPP to determine where it thinks that needs are for upgrades and additional facilities and all of that. But that's why I think some of these, to the extent what was really going on underlying in these proceedings was some concern about like spreading the costs of wind generation and that being unfair. I mean, we didn't set the policies, and neither did SPP, to have a bunch of wind generation in these zones. And so to the extent any of that is driven by policies of states, like the whole point of the cost causation principle is all that sort of drops out. And the ultimate question is who's getting the benefits and who's paying the costs. And whatever decisions may have been made by others about what energy should be generated where, we're paying an outsized share of the costs without this amendment in place and without the approvals that FERC has made in the separate 205 proceedings for this existing sunflower facilities.
And does the cost allocation scheme, like which comes first? Highway, byway cost allocation, or selection of facilities as part of the regional transmission plan?
So the highway byway methodology has been in place in the tariff since I think it was like 2010. There were some different things before.
Selection of something as highway or byway.
So it's just dictated by the voltage of the facility.
Yeah.
So yeah, so once the so the decision is made in the planning process about what kind of facilities you need, but basically by default, the voltage of the facility is going to make it either a highway or a byway facility. And that's going to dictate its costs. And so that's why, absent this amendment, just by default, just by virtue of being under 300, and 300 is the threshold to be highway versus byway, our cost would be allocated 2/3 to the local zone and only 1/3 to the rest of the region without the amendment, which allows the complete reallocation.
And how often is there SPP regional planning?
I don't actually know exactly how often they make the planning determinations. FERC may be able to tell you that, but there's constantly, it's not just a matter of new lines, it's also upgrades to existing lines. So there's a lot of changes happening all the time, and especially a lot coming online in these regions that drove this problem precisely because they have such a high volume of generation as compared to the local needs and the local grid that was set up to serve them.
Thank you.
Absent any other questions? Thank you.
Good morning. I'm Carol Banta for the commission. I do want to talk about standing, but I think I'll begin with just a quick discussion of the 205 versus 206 questions. We can't refer to the allocation orders proceeding as the 205 proceeding because this is as well. Every order in front of the court, the rejection order from the previous proceeding, the 3 orders from this proceeding, the 2 orders in the allocation, all of these are 205. There has not been a 206 complaint by petitioners or I believe anyone else challenging the existing highway byway cost allocation, which has been in place since 2010. That is the lawful rate. It was approved, or the lawful tariff cost methodology. It was approved by the commission then. It is still in place. It is still just and reasonable until the commission decides in a 206 proceeding that it is not. It has not done that and it hasn't even been asked to do that. In these orders, in the tariff order in particular, and then in the allocation orders, the commission did agree that reallocating the costs of some of these facilities outside that cost methodology might better align the costs. That's true. But as Judge Pillard, as you said, cost allocation is rough. It is roughly commensurate. The Supreme Court long ago referred to it as a zone of reasonableness. Just because it is true that a better alignment of these costs is just and reasonable, as the commission found in the allocation orders, that doesn't mean it's the only one. In fact, if the commission said there's a better way, therefore the existing way is not just and reasonable, we've been reversed by the court for doing that in a case called Ammar Main. The commission just because there might be a better way doesn't mean the existing way is unlawful. So just so we're clear that the existing cost allocation methodology continues to be just and reasonable, and that these are both 205 proceedings.
Can you explain why applying the tariff amendment would violate the ex ante principle? The commission's order denying rehearing says that SPP's proposal would provide the SPP board with the discretion to change which cost allocation method applies to specific byway facilities after they have been selected as a byway facility. Right. What is not ex ante about it if we're talking about facilities that are being constructed going forward? You'll basically have three categories: a byway facility that is charged to local zone, a byway strength facility or voltage facility that is charged zonally, and a highway voltage facility that is charged zonally. What's wrong with that under the ex ante principle?
I think if now the ex ante principle, which comes from Order 1000, happens pre-planning, and the idea is if you have these rules in place, cost allocation in place before planning, then the planning can be driven by knowledge of who's bearing the costs and who benefits, and that goes to what Order 1000 was designed to address, which was that facilities weren't being planned because there weren't rules in place, and the people or the entities considering the planning couldn't see into the future who was going to have to pay for them necessarily. So that's where the principle in Order 1000. It is true, I think, the commission in these orders, considering this discretionary process for SPP to decide cost allocation, the commission focused on the ex ante aspect, I think, with respect to the concern about reallocating existing facilities. I don't know that the commission was really speaking to the concern about potential future facilities that hadn't even been planned yet, but there very much was.
That's going to the other 205 proceeding that's not before us today.
Well, no, but they were.
I know, they were parties here, but.
No, not just that, Your Honor. I'm sorry to interrupt, but.
I interrupted you, I apologize.
The process that SPP proposed here was going to allow reallocation of existing facilities. And when it proposed that, it didn't yet have, maybe this is the only application that was submitted for an existing facility. And I'm not sure, the commission didn't really discuss the 18-month, whether that was an all-time limit that no one else could ever come in. If in fact, as the petitioners contend, this process will help going forward as new wind energy is built, I don't understand why the owners of existing facilities wouldn't be seeking reallocation when that happens, just as Sunflower did. But the process that SPP proposed did allow it to reallocate for existing facilities in addition to whatever it might do for future ones. So that's why the commission discussed the ex ante concern that you would be changing the rules of the road through this process. And that was only one of several concerns. One place I'll point in particular on JA 501 and 502. In paragraph 37 of the second rehearing order, the commission really kind of summarizes the several concerns that together it found it couldn't approve this process. One was the discretion, the amount of discretion given to the board. One was the concern about undermining the ex ante cost allocation method. One was the scope, because sure, maybe not every facility would actually be able to meet the test, but the eligibility was open to numerous facilities region-wide and not inherently limited the way a couple of other processes that SPP already had were. And fourth, the concerns about transparency, because the board wouldn't have to articulate its reasons. So this is where the commission puts all those things together. So ex ante was one part of it. Now, when we get to the allocation orders that.
Can we just
you-
focus on
Sure.
the ex ante for just one more second? I think what petitioners would say is something like, these orders treat that principle as if it's inviolate. And in fact, it's not and can't be, as your,
Right.
recent orders in the other proceedings show.
And that's what I
So-
was about to.
Right, so
Exactly.
why, it seems a little bit inconsistent.
Well, here is one factor. And again, we're letting the SPP board make the decision without going to FERC. So it was one of the factors, in addition to the others I just named, that the commission found concerning, because it would undermine the certainty of ex ante cost allocation to change it later.
But that really, I mean, and that's what I thought FERC was saying. The ex ante is really a subsidiary to the concerns about transparency and discretion. If transparency and discretion are really fully resolved, then FERC, in approving the tariff amendment, has given its blessing. And the SPP is then legitimately exercising its role
Well,
in determining which facilities meet the standards. There's
I don't think the concern about ex ante, I don't think that answers the concern about ex ante, because if the commission approved this SPP process, they would be changing the allocation of existing facilities, and it would undermine the certainty of when you're at the planning stage and you're thinking about what facilities to do, and you look at the rules of cost allocation and who's going to pay for them, and that goes into the decision of who supports building the facilities, et cetera. And then that is changed later. It does undermine the certainty that was the point of Order 1000.
So can you be more concrete about that? Because as I understand it, what's happened is there was approval of certain highway facilities and certain byway facilities with the understanding that zonal service, most of the zonal transmission was going to occur under highway facilities, through highway facilities, and most of the more, did I say zonal? The regional.
No, I think,
The
yeah,
regional
I know
was
what you
going to
meant.
go
I know
through
what you meant.
the highway facilities, and the zonal would go through byway. Then when you get up and running and the byway facility is being used for zonal distribution, it would seem that the even more fundamental ex ante principle is that those who benefit roughly should be those who pay. And when that's really out of kilter, the very assumption behind selection of some as byway and some as highway is no longer really accurate.
Well, I don't think the commission has answered that question, because I don't think that's how the commission would look at it. The commission would look at the facts had changed as to that facility. And that's where we come to the allocation order. And the awkward thing, as we've said, these orders should be considered together, because if petitioners are arguing this whole case about the cost causation and the cost allocation issue, it's not even in these orders, because, but let me explain to you what the commission found in the allocation proceeding, because the commission itself is approving a reallocation of the costs. It's not something that the SPP board is doing on its own. This is a Section 205 filing. So
You're talking about the other case.
the other case, well, they're all, yes, exactly. That Section 205 filing,
The other petition is not before us.
exactly.
For the four.
Exactly. Which since the rehearing order is done, that will move to briefing soon.
Yeah.
We've asked to have the abeyance continued to February 4th, just so we can get any more petitions for review in.
But you were going to say, in the
Yes.
allocation proceeding, what
In-
FERC did.
So when the commission is looking at it itself under Section 205, then of course some parties said, well, what about what you said about ex ante cost allocation? And the commission didn't disown ex ante cost allocation, but it said that's a policy. Order 1000 is a policy. But when you come to the commission itself with a Section 205 filing, and you make the showing that your proposal is just and reasonable, and that it's that the cost allocation, the benefits are roughly commensurate with the costs, we have to approve that under Section 205. And the fact that it would undermine certainty with regard to ex ante, that's a policy, and the policy cannot override the statute. So when the commission itself is making the decision, then the ex ante becomes a secondary concern that doesn't win the day. But here, we're not talking about the commission making a rate determination. We're talking about the SPP board making the rate determination. So the commission's ex ante policy it did find it one of several factors, not the deciding one, not the only one, but one of several factors that listed for why it had concerns about the discretion given to the board.
Why do you say SPP, not FERC, is making the rate decision, since it would be FERC approving this tariff as it initially did? That is FERC.
But it's not, but it's not a filing made with the commission to reallocate the costs. It would be allowing.
Tariff systems were always sort of there's
Well,
formula, there are principles, and then.
It would be approving a process. And I think that's just why the commission treated it a little differently with regard to the concerns about ex ante. It has the same concerns throughout, but it finds they're overridden in the allocation proceeding because it can't deny the Section 205 filing by SPP to reallocate the costs on the basis of a policy when it meets the standards of the statute.
I have a
At least that's how it
question
explained it. And again, if I had all the orders.
I probably should ask this of Ms. Murphy too, but if the byway facilities are already constructed and they were constructed on the assumption that they would be serving zonal load, why is it that there are higher expenses associated with regional transmission over facilities that were built and budgeted as zonal facilities? I guess it's sort of the inverse of the question that I had for Ms. Murphy about why is it that traditional generation, fossil fuel generation, tends to do zonal service through highway, whereas these wind facilities are serving the zone through byway facilities.
I'm not sure I completely understand the question.
There's in the blue brief, there is a discussion of how Midwest and Sunflower customers are paying much higher byway costs than other zonal customers elsewhere. And I guess I'm just wondering if each byway facility is just constructed as a 300 megavolt facility, why would it become more expensive if it's being used for
It is
wind
not
power?
right. It's not my understanding that it has become more expensive.
More byway facilities there in order to.
Well, and I
serve.
think, and I don't want to speak for them, but my understanding of the issue isn't that, I don't think it's that they have more costs, although maybe more byway facilities are being built to accommodate that generation. That's possible. But certainly they're saying of the costs of that facility, we don't think the people in our zone should be paying 67% of it because,
That's common.
Unless more are, unless more are being constructed because the need for more interconnections, that might be it. But if it's the same byway facility, I can't imagine it gets more expensive when it's connected to.
But I think
Right.
Ms. Murphy will
I'm
surely answer this
kind
question, of course.
kind of guessing in that regard. I do want to touch on the benefit criteria point. To be clear, the commission has not abandoned that argument. It's not only the interveners that made it. The commission in the orders, in the first rehearing order, paragraph 52, I believe, and the second rehearing order, paragraph 41, talked about, now, and it is true, as it said in the tariff order, that both of these metrics are fine. The commission itself has approved rate filings based on both metrics. So the commission said it's fine to use one or both, one, the other, or both. The problem, as the commission described it in the two paragraphs I just cited, is not that they're inappropriate to use. It's that it really goes to the board's discretion and the transparency question. Other parties need to understand what was the deciding factor, which criterion or combination of the two criteria mattered in this case, because you need to.
I think that concern would make sense if we had a reason to believe the two metrics would sometimes or often or maybe point in different directions. But if we don't know that.
Well, I think what the reason the commission has seen them both is because parties will sometimes do one or the other and not both. So I don't know that we have the data on if you meet the first one, do you always meet the second one? It's more a flexibility in how can you prove your case. Both of these prove something
I would
I-
really
So-
appreciate
yeah.
more clarity in terms of concreteness, the specific case you're imagining. Because if you have two different parties who have made the same kind of showing, I can't imagine a situation in which the SPP would treat them differently. For example, if
No.
both, well,
But-
for example, if both of them say, we're only going to do the integrated marketplace methodology, and they only make a showing as to that. I mean, it would be arbitrary and violate at least what we do when people make showings. We don't say, well, you made that showing, but we wish you'd made this other one. I mean, I don't think that's a case in which
Right.
SPP would treat them differently. So maybe one makes both showings and the other only makes the first. And if the first is inadequate as to both applicants and only the second makes the case, then people have made different showings. So the one who made the more robust showing should prevail in a
Well,
way. There's nothing arbitrary about that either.
Well, for one thing, we don't end up knowing what was decisive for the board. What
Well,
did
but
the
we
board
do
think?
know what they've submitted because you've had all this
We
public
know what was recommended to them.
proceedings, know what was recommended, what was in their application.
We don't know what they were persuaded by ultimately, and they don't have to explain it. So the next party that comes along is not able to say that utility showed X% under this metric or Y% under this metric, and so do we, so we should be treated the same. They can't even make the case
They
because,
because what they proposed is public. So
yes,
black
but-
box or not, you can say we were similarly situated in every respect and we got treated differently. That would be a very strong 205 petition, wouldn't it?
it would be useful, but I think that the commission here was just the final decider can't be a black box. I mean,
I'm not following, and it would be really helpful if you could explain sort of a situation in which there's this kind of showing and then a similarly situated applicant makes the same kind of showing and is treated differently. I'm having trouble even envisioning this coming up.
well, I think the problem for the commission is that in approving the process, the commission didn't think it could allow a process where it was theoretically possible. We don't have a concrete example because we only have one entity that went through this process at all.
I mean a kind of algebraic concrete, a hypothetical.
And I'm afraid I don't think we have that because the commission likes to be flexible in how parties can show benefit. And that's why it has allowed different metrics in different cases because that's what the party brought and the commission was able to look at it. But in setting up a flexible process where the SPP board could consider one or the other or both, say you don't quite make what the commission might have allowed under metric 1 or quite what the commission might have allowed under metric 2, but you think you can make a case based on both of them. You're allowed to do this, but we need to understand what happened so that the next party that comes along can understand what happened.
So let me
And-
just ask, you're not asserting that the board would review an application under a methodology that the applicant didn't use. So they would review the showing that the applicant made and the applicant's choice.
Well, they
Oh,
might have
okay.
multiple showings in the recommendation from the
They might, but
staff.
that's not what I'm
but
asking.
we'd-
That they wouldn't say, oh, you've used the first methodology and we prefer to look at your application under the second.
We don't know. I mean, they
Think that's a
are,
possibility?
as written, yes, I think so. And again, the commission may not think that's actually going to happen, but the commission is being asked to approve a process, an open-ended process that might be different in different cases. And if we're talking about extended into the future, the commission has a responsibility to judge the process itself.
Right. So if it had said the APC methodology is preferred, so everyone has to try to show that. And if you think either that may be inadequate or that you also want to use the integrated market methodology, you may do that. Would that create the undue discretion if you have a clear 1-2 priority so that we know everyone's being considered for whether they clear hurdle 1, and then if they've chosen to show
I
hurdle
think
1A.
ultimately we just don't know what the decider thought of it. It's as though you went through an entire commission proceeding. Our whole docket is public, except for, rare exceptions of something that's privileged for some reason. The whole docket is public. Maybe we have technical conferences that are public, all sorts of filings by everyone. And then the commission doesn't issue an order. Now, we don't have that option because under the Administrative Procedures Act, obviously we have to, but you could say the entire commission process was public and all the suggestions that were made, all the evidence that was put in, everything was public. But the commission vote took place behind a closed door and we didn't issue a written decision. I mean, that's the difference. That, when the commission makes a decision like this, everyone can look at it and we can come to court and people can say that we're wrong and the court can decide whether we were arbitrary and capricious. The next party that comes along can cite that as precedent and say, well, in that case, here's what the commission did. It's open, it's transparent, it's explained, it's
Did the SPP board vote by secret ballot on the base plan upgrade
yes,
and on the transformer waiver process?
yes.
And why wasn't that an issue?
Well, and the way the commission explained it in several places, and one actually is before this proceeding, in the rejection proceeding, so it's at JA 34. But then it also said the same thing in our orders. And it talked about the base plan upgrade waiver process and the transmission waiver process. They both have, the commission said basically that it's a matter of scope, both the number of facilities that might be affected and the amount of costs. Because we're talking about potentially a number of facilities, and they're pretty large facilities, even byway facilities are not small. So it's a lot of costs with the base plan upgrade waiver process and the transformer waiver process. They're both inherently limited by who's even eligible to think about it. The base plan upgrade waiver process has something to do with a review that SPP does that comes up with a very small universe of projects that are affected. So the commission said it's limited in scope. The transformer waiver process narrowly pertains to dual voltage facilities. They're necessarily limited because there aren't that many dual voltage facilities and it's obvious to everyone what they are, and they tend to only be in certain places where one voltage meets another. So the commission said there are significant restraints on the scope. So, and again, that goes to the paragraph I had mentioned earlier in at JA 501, 502 of the different factors, including the ex ante issue. The commission again cited scope. The difference is scope.
Why doesn't everything you just said apply to this? If we went through this and we learned that of all the many facilities, 4 thought they were eligible.
Well, because we're talking about a process that any byway facility could apply for. Maybe they wouldn't all get it, but we're also extending it into the future. So the commission, and they're larger and more expensive than these dual voltage facilities we're talking about under the transformer.
So it sounds like today it was something like 1% of facilities thought they could apply for a waiver. So if going forward, 1% of all new facilities apply for a waiver. Just doesn't sound like.
Well, we don't know
material
that
difference.
because the eligibility is more open than that. That may be how it plays out in practice, but the commission is having to approve a process that would be in place even if it turned out that that was wildly wrong and it was many more. So the commission is very much looking at the process. And again, since
it's up to the Southwest Power Pool to determine where and when new generation can be built.
not generate
New transmission.
transmission. Yes. Not the generation is driven by companies making their own decisions and then asking to interconnect, and then SPP and its various members respond to that by building the transmission facilities that are.
FERC would have no concern if, for example, a wind field were constructed and SPP said, okay, let's build a highway transmission line from there.
I mean, if they went through their planning process that's in their tariff, we have no reason to question that if they did it according to their process. Yeah.
And in terms of the other 2 waiver processes, timing of those and any ex ante concerns that they raise, why are they different?
I don't know that, I don't know as much about those processes candidly, and I think that I don't think they involve existing facilities. As I understand them, they are facilities that are going to be built. if I'm wrong about that, it's just not in the orders, but the way it's described in the orders, it does seem to me that it's something that happens at the outset and not something that happens later.
I had assumed otherwise because they're referred to as other waiver processes. And
Yeah, and waiver is a tricky term, but I mean, even at the planning, you have something that's designated as highway or byway at the planning stage. So my understanding would be, these would be saying, okay, we look like a byway because we're 100 to 300, but please treat us differently because we fit this category. That's my understanding of how those, because again, if I'm wrong, I'm not aware of something in this record that discusses that. So that was my understanding.
Do you know if there's any decision for which SPP does have to issue a written decision and explain its rationale?
Well, I mean, I don't know, but no, I don't know of one, but also it's, I mean, what was unusual here is that they don't usually determine cost allocation. Right. So, so I think to the commission, that was the difference, because we do have this 205 section 205 responsibility to have cost allocation decisions be transparent, so that you don't end up with disparate outcomes.
And nothing would stop FERC if it wanted to, if it thought this scope was going to be a problem, it could open a 206 proceeding and address this.
It has the discretion to do that, but yes.
I know nobody can force you to, but I mean, in terms of the concerns that,
Right.
Maybe we're going to have a whole, it's going to upend the assumptions on which the planning was conducted in the first place.
Right. And I mean, SPP isn't here to speak for itself, but I would think if there were many facilities that were actually applying for this, you would think that they would revisit their own cost allocation methodology. But yes, the commission would have that power. And that brings me, I do just want to make a couple points about standing, because of course, SPP did not petition for review. This is SPP's tariff. So if there were a party that was the object of this proceeding, it was SPP.
Aren't they an intervener? Aren't they an intervener?
They're an intervener, but they didn't seek review. So I'm just saying, if we're talking about standing,
We have cases, including one called Ammar, in exactly this situation where the RTO comes in as an intervener and we find they have standing. We don't even need to address the actual petitioners. So do you have an argument that SPP lacks standing?
well, we don't know, because they didn't talk about harm. I mean, they're the object of the proceeding, but that doesn't necessarily mean that they incurred an Article 3 cognizable harm. But I mean, they weren't even given argument time to explain, so I don't know. But so the argument we made on standing, I mean, the clearest argument we made on standing is just that this court has been saying in numerous cases for a couple decades that you have to explain it in the opening brief. And the court has had cases where it said, you didn't explain it in the opening brief, we're not going to let you do it later and make up for it.
But all your arguments about the potentially tremendous scope of this and the disruptive potential of it, that seems to at least undermine the standing concern. There's a lot of import to this going forward.
Well, there could be, but we don't have any explanation of why these petitioners were harmed.
And intervener.
It didn't, I mean, it said that it was its tariff, but that could be, but of course, the only, as we've discussed, the only facilities that anyone applied for, at least when this was in effect, have been reallocated by the commission itself. And given how much discussion we've had of the cost causation and the roughly commensurate and all of that, at a minimum, if the court were going to delve into those issues, we really should do it when all the orders are before the same court. Consolidate all the cases, because this is the process side, and that
But you didn't file a motion to consolidate. You didn't file a motion to hold this case in abeyance.
Well, we proposed a motion for abeyance to the petitioners, and they wouldn't consent to it. And since briefing was already underway, we knew that the court would defer it to the merits panel. We didn't think that filing an opposed motion when briefing was underway would be a useful exercise. So we proposed it in our brief that it should be in abeyance. Because the first allocation order did come down after they had filed their opening brief. So briefing was already underway. But we certainly would support consolidating them. And we did want in late July, early August, we wanted to put it into abeyance then, before the rest of us filed all our briefs and the court took its time today. But we couldn't get agreement on that.
So I just wanted to circle back because I was asking you about the base plan upgrade waiver process and whether that had the same problem of disrupting expectations that were established through the regional transmission cost allocation planning process. And in the commission's order denying rehearing, the commission says both the base plan upgrade waiver process and SPP's proposal in this proceeding relate to regional transmission cost allocation and bestow discretion upon the SPP board to grant a cost reallocation request. So it seems from that, and I'm looking at JA 499, paragraph 33, it sounds from that like the base plan upgrade waiver process would affect
Okay.
prior regional transmission planning. And I guess I'm trying to understand.
Well,
You said you think it's dealing with a more finite group of
it is more,
facilities, but it doesn't
yeah.
seem to be distinguishable in terms of ex ante or not.
It is distinguishable in terms of ex ante for a different reason. And I apologize that I didn't pick up on that there. But 2 paragraphs previous, in paragraph 31, the commission does say that the base plan upgrade waiver process isn't subject to Order 1000's rules regarding ex ante cost allocation because those are not facilities that are selected in the regional plan under the Order 1000 process. They're selected for different reasons and aren't.
Are they base plan upgrades? I mean, in a way, it sounds a lot like what we have here.
I truly don't know. There's something different and more limited, and they aren't planned as part of the regional planning, and these facilities are. And I wish I did know more about them. I'm sorry that I don't, but the commission did find them kind of a weird little category that it's on its own. They're identified in a particular study that SPP does that has nothing to do with all the rest of this. So they're kind of a quirky little, and that's why they have their own waiver process that I think
It might be helpful, given how much this is at issue, if you would submit a letter or something on that, just to explain.
Okay.
'Cause it's not clear.
Okay, sure.
I appreciate the reference to paragraph 31, but I think the paragraph 33 is somewhat in tension with that.
Okay, yeah. Of course, 33 does emphasize the scope point, but I take your point on that. We'll submit something. Court has nothing else. Thank you.
I was told it should be chin height, so I apologize. Okay. Thank you. Charlotte Taylor for intervener supporting respondent. I wanted to talk about standing briefly and then a couple more thoughts on the ex ante cost allocation as it relates to the discretion that SPP's board has. So on the standing issue, with respect to these 4 transmission facilities, though the fate of those is going to be conclusively determined one way or another in the separate proceeding that is also before this court. It's not a case where this could go one way and there would still be a live controversy, or another way and the controversy will be terminated, because the outcome of that is going to be either it is just and reasonable to reallocate the costs for constructing those facilities and running them on a regional basis, in which case Sunflower will have achieved all of the relief that it is seeking for any concrete controversy that's currently presented, or the outcome will be it is not just and reasonable to reallocate, in which case I don't see any world in which it would be appropriate to go back to SPP and use the black box waiver process to seek reallocation of costs for the same facilities that has already been determined by FERC and potentially affirmed by this court would not be just and reasonable. So then standing would have to be based on the prospect of future use of this waiver process. I would note that SPP at Joint Appendix 546 has specifically said it does not foresee another future filing similar to the proposal before the commission. It also did not join any argument with respect to standing in future facilities in its own brief that it filed in reply. So SPP has not come forward saying, we do think that there's going to be future use of this waiver process that justifies this court, Article 3 standing in this court, rendering a decision.
You're speaking in terms of standing, but it seems clear that at the outset there was standing. And so the question really is a question of mootness. And the reason that's important, as you well know, is that the burden is on the defending parties to establish that the dispute is moot.
So in the cases that say that there's a heavy burden to show mootness, those are cases where it's the defendant or respondent who's saying, now we voluntarily cease the offending conduct. This is not that case. What's made this moot is that SPP with Sunflower sort of in tandem went and initiated another proceeding in which all of that relief is going to be sought. So I don't think that I think, this would be in the sort of typical mootness analysis where it's just standing in a time frame. And with respect to those 4 facilities, there's no longer standing because they've been sort of, split off, and there's going to be an up or down decision at the end of the day about reallocation for those. So then any standing would have to depend on the future use of this waiver process. And there, I think we just have, Lujan has its, very well worn, but I think very helpful, admonition that someday intentions without any description of concrete plans does not support a finding of an actual or imminent injury that the Supreme Court's cases require. And that's all that there is in the record excerpts that petitioners cite. If you look at that, those are, affidavits saying, it is reasonable to expect that there are going to be future invocations of this waiver process. But there's no actual, concrete case in which that would be, that we know about that's coming down the road. And that's just not enough for Lujan and for the purposes of standing. In the cases where the intervener, I recognize that SPP has intervener, if it has standing, then that would be sufficient for Article 3 purposes. But if you look at those cases, there's at least something that the RTO or similarly situated entity would have to do. So for example, in the Ammar case that we cite in our brief for this proposition, the relevant RTO is going to have to go amend its tariff, right? But here we just have the rejection of a tariff amendment. So SPP will be not in a position to do anything. It just will not use this thing that was proposed.
Why is that the way to look at what happened here as opposed to there was an amendment to the tariff allowed and the order on review now strips that authority out of the tariff?
Because it was never finally approved, right? So there was sort of that interim order said, make this amendment and then, we think it'll be okay. Then we sought rehearing of that and made arguments and others, right? And made arguments for why it was inappropriate. FERC changed its mind, but it was never accepted. And in other cases, such as the New Jersey versus EPA case that's cited, New Jersey was able to say, on an ongoing basis, we're harmed by these record-keeping requirements. There's upstream pollution that is affecting us. And so that's the kind of harm that supported standing for sort of the, equivalently situated party. On the merits, I'm happy to talk more.
Just ask about so what would the practical result of that be? It would be SPP doesn't have this authority. So when there's another facility on the horizon, even if it's not enough, wouldn't be enough for standing, then they have to come and reinitiate this whole proceeding, or would they even be able to mount a collateral attack on?
Well, first I would
already
just note that it's pretty well established that just because, if you don't have standing now, the fact that might frustrate review eventually doesn't create standing in the current controversy. But again, SPP doesn't believe that that there is going to be such a case, and I think that's very relevant to the standing inquiry. But yeah, I think that the result would be that this waiver process would not exist, and it wouldn't be used in future, and so it would not be challenged on the merits. But that's a fact of in large part because SPP did not come forward and say yes, as regulator we anticipate that this will be used, and here's why. On the question of the ex-ante allocation on the black box, I just wanted to sort of take a step back and think about how this is going to look. So if you go back to Order 1000, The reason why that was adopted was already because there was anticipated expanded use of renewable energy sources, and there was going to be a need for this kind of regional planning process. After that, we have SPP institutes the highway byway methodology that is designed to take into account of precisely these types of considerations, that there's going to be, some facilities are going to be long distance transmitting power. And everybody engages in a planning process that with the highway byway methodology in mind, right? Up above a certain threshold, it's a highway. In the middle, it's a byway, and it'll be allocated this 2/3 one way. And then locally, it will be allocated for the lower voltage transmission projects, it will be allocated locally. Then everybody goes through that. We get to a result where something is allocated to be a byway facility and SPP approves construction of it. Then you have who knows what this process is going to look like in terms of the amount of consensus, because there's so many different moving parts, right? So the SPP staff issues a report and recommendation that goes to the SPP board and the RSC. Then the cost allocation working group issues a separate report and recommendation that goes to the regional state committee. All along the way, stakeholders are submitting comments on these public recommendations and are very likely to have disparate views about whether the factors are met. And then you get to the SPP's final determination, and it's, doesn't have to say why it came out one way or another. That's the process that if you go back to ex ante, the sort of, the planning, people won't know what's going to be the outcome of ultimate cost allocation for the byway facilities. So that's why this sort of discretionary black box method undermines that key principle in Order 1000.
When did the regional planning take place, and how often does that occur?
So the regional planning process, I don't know this precise timelines, but that is the way in which the construction of new facilities, like the need is identified, and then they are approved through this collaborative planning process.
You don't know how often it takes place?
No.
When this occurred?
I don't, on an ongoing basis. Or certainly, it's a regular, the purpose, one of the main functions of SPP and under Order 1000 is to identify the need for transmission projects.
How discretionary is the proposed tariff amendment anyway? It uses directory mandatory language within it.
So it says that the 3 criteria are the only criteria that SPP is supposed to consider, but it doesn't take that extra step and say when they're satisfied, then this is approved.
Oh, yes, it does. It says it has to be decided based on the 3, and therefore if they're met, it has to be approved. If they're not met, it has to be rejected. That's the way I read it.
I think it doesn't say if they're met, it has to be approved. If they're not met, it doesn't get approved. It says it shall be based on those 3 criteria.
If that's a fair reading of it, and we think that that's the way it should be read, then doesn't that solve the problem?
Well, I think you still then have the problem of the fact that we're just really not going to know. So it's not going to be a scenario where the SPP staff makes a report and recommendation, says, here's why we think the 3 criteria are met. And then the SPP board sort of votes yes, right? It's going to be a much more messy, contested process in which you have, a couple of different reports and recommendation, and also input from all of these different stakeholders. So even if we assume, I think, then we get to the problem of, so what do you do with that, right? Even if we assume that SPP only considered those factors, it's going to be a contested factual question as to whether they were met, which study to rely on, why they were met. And then that's not what sort of, administrative process is supposed to look like. I think that, then you get to the other side of it. It's like, well, why did SPP conclude that the benefit criterion was met? And we just don't know.
The application and its analysis and the SPP staff's response to that is all in public record, and there's a hearing at which stakeholders can show up. So the entire record indicating which way that points is transparent.
But the reasons why, so again, it's as my colleague said, it's as if, FERC went through the entire process of having everybody participate and file briefs and make a record, having a technical conference, and at the end of the day, it just, says sort of, thumbs up, thumbs down. That's not.
But the hypothetical is basically there's a staff recommendation and everything in the record seems to show all three criteria are met. And all you get from SPP is denied. And then not only do the current parties not know, but future parties can't compare themselves to whatever
Correct.
happened in that proceeding in any intelligible way. Is that
Right.
basically the point?
Yeah, that's right. And that also undermines the predictability, right? So even if in theory, you could then bring a 206 proceeding to the challenge to the outcome and say this is not just and reasonable, that's not, how this is supposed to work. You're supposed to know in advance at the planning stage how any individual cost allocation is going to go. And then, to the extent that there are, overarching cost allocation or cost causation problems, then that's where 206 comes in again. And I think that's something that petitioners really sort of are sidestepping, which is, there has never been a demonstration that the existing highway-byway methodology is not achieving the rough approximation that cost causation requires in the aggregate. And in fact, the RCAR process, which just, wound up, didn't show any overall imbalance. So it, may be permissible in, the separate proceeding. There's a request for FERC to approve as just and reasonable, a sort of specific fine tuning of that. But the overall process is, has to be presumed to be achieving appropriate cost causations. And even if you don't want to presume that, you can look at the RCAR analysis that just took place.
Where is that when you say the RCAR analysis that just occurred? That's regional planning, right?
So that's built into the highway-byway framework, and it says every 6 years there has to be an overall assessment. It looks at costs and benefits for each zone and comes up with a ratio. That ratio gets out of whack, then there's a process to apply for, some relief. But so far that.
A page number to support what you were just saying about how that showed there was no cost causation imbalance.
I can get you I will, let me grab that for you at the end. I just wanted to so I think that isn't directly, we're not claiming that the RCAR, analysis, is directly at issue in this record, though. It's, here, the commission appropriately decided that this is just too discretionary, too uncertain. It's not going to create enough guidance. And so it is intentioned and trumped by the need for ex-ante cost allocation determinations. In the other proceeding, I think you will hear more about the RCAR outcome. And I apologize, I'm not able to find in my notes the page number for the RCAR description.
Didn't the other waiver provisions that were mentioned in the papers before the commission and to us also get approved by secret ballot by the SPP board?
Yes.
And that's not problematic in terms of excess discretion because?
So I think for slightly different reasons. First, I think both of them are much, much narrower in scope than the potential applications of this, right? This applies to any byway facility. It doesn't have to be linked to renewable generation. It doesn't have, any temporal limitations.
But it has the first two factors, which show, which are an effort to identify which byway facilities are really serving zonal load.
Right, but any byway facility is eligible. And just as a practical matter, the costs of constructing new transmission just far outweigh the cost of, for the transformer waiver. That's a very narrow subset of, it's just a smaller piece of equipment that connects a low voltage to a high voltage facility. And then for the base plan upgrade waiver process, again, that is not part of this regional planning process that is specifically subject to Order 1000's ex-ante cost allocation principle. And so for that reason, it was not arbitrary and capricious for the commission to decide, when it's not even part of the Order 1000, it's not even under that umbrella, or when it's, in practical terms, a very, very small, not very relatively expensive subset of applications, it's not going to be, overall problem in terms of our ex-ante cost allocation policy to allow SPP to exercise some, discretion and have that, secret ballot, sort of similar procedural requirements. But when it's something as potentially significant as regional cost allocation for these very expensive transmission projects, then we do need to conclude that this is just too much discretion. And I would also just underscore that petitioners are trying, they say, well, this is all that's changed is the composition of the commission. The composition of the commission was just that Chairman Glick, stepped down, but it was the same. Two of the commissioners just thought it over and changed their mind, right? It's not a case where you had a sort of one new appointee and then it went from 2-3 to 3-2. You had a very thoughtful concurrence from the commissioners, Clements and Phillips, saying, they were on board, but then that's what rehearing is for. They heard our arguments on rehearing and those of others who participated, and they said, you know what, at the end of the day, as much as we supported this in theory, there's simply too much discretion for SPP for this to be permissible.
It's hard to read the record and the background in terms of the amount of stakeholder involvement and think, well, what's needed here is something with stakeholder involvement. Because it seems like there was many opportunities and in fact, a great deal of stakeholder involvement.
I mean, I think, yes, certainly this is a process that everybody put a lot of thought into, but I think that was essentially, saying we appreciate that, that you've tried this, but when we finally got to the end and looked at how this was going to operate, it's simply not going to be, allowable to do this where SPP doesn't issue, an opinion, doesn't provide any guidance. You have, and so, come up with something else, go back and, work again with the stakeholders and try again if you think that there's an overarching problem here. And meanwhile, there is the mechanism that's being used in the separate proceeding, which is that for individual facilities, if those are out of balance, then SPP can, as it did here, seek, case by case cost reallocation, show that it's just and reasonable. Of course, we disagree with that, but we're going to have that fight in the correct procedural posture, which is through presentation to FERC, which is the federal agency with congressionally delegated authority to make these decisions. And it can decide what's just and reasonable. And that will be reviewed by this court on a record that doesn't include a decision maker that didn't offer any explanation of its reasons. Thank you. Sorry. For the RCAR, Carol's, it's JA 235. Okay, thank you.
Thank you. All right, does Ms. Murphy, she reserved no time, but we'll give her 3 minutes.
Thank you.
If I can make just a few points about standing and a few points about the merits. First on standing, I think it was quite clear in our opening brief that we had standing. We laid out not only that we are entities that are members of SPP, but also explained that Sunflower had sought those waivers while the existing process was in place. And as FERC and respondents have acknowledged, at the time we filed our opening brief, the FERC had not granted the 205 relief. So if there was a change in circumstances that happened after our opening brief, and as we explained in our reply brief, there's not a mootness issue for the reasons we've already discussed on the existing facilities. I don't take respondents to dispute that we have a live controversy there.
She made a kind of a novel argument that this is not a case where FERC has said, oh, we're going to peel off these petitioners and resolve their problem and thereby moot the broader concern. It's a situation in which petitioners filed a separate petition. So in a sense, they peeled off. And then the question is, she, as I understand it, is saying, we shouldn't look at this as a situation in which the burden is shifted. The standing has sort of been gutted in this Section 205 proceeding by the petitioners getting the relief, the only pending relief that they are seeking in that other proceeding. And yes, that's not final, but apart from that, how would you respond?
I mean, it is a novel argument that I don't recall seeing in their brief, but I'm not aware of any authority that really says that mootness is only your burden if you're a party who tried to affirmatively moot a case. In any case where you have mootness as an issue, it's always a high burden to satisfy mootness. I've never understood that to be a doctrine that's confined to circumstances involving something like, voluntary cessation or whatever it may be. It's just a burden to demonstrate mootness because mootness is trying to essentially overcome the burden that's already been satisfied in the first instance of showing that you have standing. And now I also heard a little bit different argument today about this idea that the FERC those 205 proceedings are kind of binary in the sense that they will definitively resolve this no matter what, one way or another. I don't see how that seems right either, because it's absolutely open to challengers in that proceeding to make procedural arguments, not just substantive arguments. And they could easily be making arguments that they don't think FERC adequately explained its reasoning, whatever it may be, that could not definitively resolve the question of whether we're entitled to the relief. So those arguments are all on the table. That is all issues that can still be live before this court. So there's very much still a live dispute. Again, we absolutely think FERC got it right in those orders, but that's not the question for purposes of jurisdiction.
Can I ask you why Sunflower or Midwest or SPP didn't file a 206?
Yeah, we think it makes sense that given all of the stakeholder process that went into this, to first do what we believe we have a right to do, which is challenge FERC's rejection of this process, of this tariff amendment. And it makes more sense to start with, let's defend the product of the stakeholder process rather than throw all that out and go do a 206 and say, let's start from scratch and have FERC think about this differently. You know, we absolutely have a right to come here. We've got here an effort to put in place a waiver process. We're the parties who would want to seek waivers. It makes a lot of sense for us to say, let's review whether FERC had adequate justifications for rejecting this process before we say, okay, let's kind of go at this through a completely different route, through a completely different set for a different kind of petition in which you wouldn't be looking at all the work that was put into this to get where we are today.
And none of this came up in the RCAR process?
No, the RCAR process, I do want to make very clear. I mean, FERC explicitly rejected the reliance on this argument. At JA 331 in the approval order, it explained that the RCAR process is not something that was a basis to reject this. So that is not an argument that FERC has embraced. It never backed away from that. It doesn't make it in its brief. So really there is a Chenery problem with respondents introducing it in this particular proceeding. But again, as FERC explained in more detail in the separate allocation 205 proceedings involving the sunflower facilities, the RCAR process is just different. It's something that happens every 6 years. It's not something that requires there to be tariff amendment changes if you identify an issue. And it's looking at things at a different level, at the zonal level. It's not focused on identifying if there's particular facilities whose costs aren't being adequately allocated. So I don't think it provides any basis to reject this order.
I guess another question is, why wasn't that actively used by Sunflower Midwest SPP to validate the results of this process?
It's just not a process that looks at things the same way. It doesn't involve the same kind of criteria. It's just a process that's designed to the point of it is to be looking at on a going forward kind of 40-year basis is what is in place in the tariff right from a big picture standpoint. It's not looking at it at the detailed level that we're looking at here. And it only occurs on a set timeline and all of that. So it just isn't designed to answer this question, which I think is why FERC has never accepted the argument that we should be doing this and be constrained to do this through the RCAR process instead of by working through a proposed tariff amendment that identifies a cost causation problem and a solution to it that FERC has never denied would produce just and reasonable rates. And what I hear FERC saying today in defense of that, I think we're down to just transparency and discretion, because I understand FERC's argument to be that the ex ante concern is really only a byproduct of transparency and discretion, not an independent basis for rejecting this. And on the discretion point, as this court the questioning has gone through today, it's just not right to say that the board doesn't have to grant a waiver if the criteria are satisfied or deny it if they aren't. That's the necessary implication of saying your decision has to be based solely on whether all three criteria are satisfied. If you're acting on any other basis, you're violating the tariff. So what it seems to come down to is this whole black box concept. But the problem with that argument, is SPP's board does all voting in secret. That's part of its tariff. It was designed that way because FERC wanted SPP to ensure that the board had sufficient independence. That's why all votes on everything, including cost allocation issues under the other waiver processes we've discussed, are taken in secret without any kind of written explanation. And it's why I think, if you look at the reversal order, so this is the order where FERC's rejecting this, they nonetheless went out of their way to say, this is on JA 499 at footnote 62, that while the SPP board votes in secret, this feature of the board's governance is not at issue in this proceeding, nor do we suggest any deficiency in it. So they said they don't have a problem with the fact that the board votes in secret, and I don't really see how they could, since that's what the board does in every context. They've never taken issue with it. They've never said the board needs to issue any kind of opinion. And there's not really any problem with reviewing it. I mean, the same way that this court—
They're not questioning it for what SPP appropriately does, but they're saying, and this is not the kind of thing that they should be doing. That's how I understand their argument.
I mean, I just don't think it's not consistent with the history of how FERC has dealt with the SPP's board when they're exercising discretion in other contexts. And I don't think this argument that because they vote in secret, the whole process becomes a black box process really works in practice. I mean, just as, this court, if a district court issues an opinion without a lot of reasoning, this court doesn't, you don't just like throw up your hands. You can look at a record and determine whether the decision is consistent with that record. And all of the transparency that was introduced into this process ensures that if you have the hypothetical scenario of everybody said the criteria is satisfied, there's nobody really even disputing it, and all of a sudden you get a denied ruling from the board, you're going to have an extremely powerful Section 206 application that's going to produce an opinion from FERC that says, it's actually 206 in that context, because if you're challenging the denial of the specific, how they acted on the specific cost, you'd go through that process. But you're going to get a FERC opinion that's going to say, no, the tariff says if they're satisfied, you have to approve, and there's nothing in this record that gives us a basis to think it won't be. So I just don't think these concerns actually have any basis in reality.
Thank you so much, all of you. It was a very helpful argument. Case is submitted.
Case number 23-5006. Sylvia E. Farrington, appellant, versus Alejandro N. Mayorkas in his official capacity as the Secretary of the U.S. Department of Homeland Security and United States Department of Homeland Security. Ms. Lees for the appellant, Mr. Walker for the appellees.
Good morning, Your Honors. May it please the court. My name is Catherine Lees, and I represent the appellant Sylvia Farrington. I'd like to reserve 2 minutes for rebuttal. The district court's decision to dismiss Ms. Farrington's complaint should be reversed for 2 basic reasons. The first is that the court used the higher standard typically used in Rule 56 motions for summary judgment instead of the Rule 12b6 motion standard that should have been applied in analyzing the sufficiency of her claims. Second, Ms. Farrington plausibly alleges several facts that bear upon causation, which is the main reason that we are here today. The appellee, FEMA, does not dispute the first 2 allegations of the claim, one being that Ms. Farrington alleged unprotected activity, and the second being that she suffered from an adverse action. So really, we're here today to discuss causation and whether Ms. Farrington sufficiently pled facts that bear upon causation and pretext. So I'm going to start briefly with the standard issue. The district court improperly applied a higher standard of proof used at the motion for summary judgment stage instead of the standard that should have been used for a motion to dismiss. In fact, every case cited by the district court was decided at the motion for summary judgment stage or the motion notwithstanding a verdict stage, Rule 50 and Rule 56, rather than Rule 12. So FEMA argues that these cases are instructive, and we agree they are instructive, to show what a plaintiff needs to do to get to a jury trial, not to get to the discovery stage, which is where this complaint should have proceeded.
Well, they're instructive in that you have to plead facts that, when you review them, take them in the light most favorable to the plaintiff, if proven, would make a claim.
Correct.
And so you to the extent that there's cases out there that talk about what evidence is or is not sufficient, they're going to be relevant to what facts being pled are or not sufficient, right?
Correct. Yes. And that brings me to my second point, which is the facts that Ms. Farrington alleged. She alleged facts that directly bear upon causation in this case. What's primarily briefed both at the district court level and before your honors is the issue of temporal proximity. While we admit that there was a large gap between the first EEO complaint that Ms. Farrington filed, you have to look at the ongoing, continuing acts of protected activity that Ms. Farrington engaged in. So we're looking at not only the first complaint, but also her and her counsel's attempts to argue discrimination as it relates to the initial 2005 EEO complaint. So when we're looking at temporal proximity, FEMA repeatedly argues that the time gap is just too large. And yes, that may be true, but we're looking at a pattern. We're looking at a continued engagement in protected activity, which should have afforded Ms. Farrington the protection and thereby shortening the time gap that the court could look at when examining temporal proximity. But it goes beyond that, right? So we have...
Well, for that argument, the suggestion must be that there are alleged facts of protected activity closer to 2015.
Correct.
Than the district court gave you credit for. And so what are those specific?
Sure. So there's a few different instances that we can look at. The first is as it relates to this issue of Ms. Farrington's debt. So FEMA argues that the reason for Ms. Farrington's termination was that she had this outstanding debt that was raised in a background check. Throughout that entire process, Ms. Farrington and her counsel were opposing the reason for this debt in the first place. They were arguing this is because of the original act of discrimination and the agency's ongoing failure to abide by the EEOC's order, which is actually continuing to date in the district court. So we're not just looking at 2005, we're not just looking at 2012, we're looking at every instance that Ms. Farrington and her prior counsel communicated to the agency, this is the reason for the debt. The reason for the debt is...
So if I was going to look in the complaint or the allegation that says we complained about the debt in 2013, 2014, or early 2015, where would I find that?
So we don't have the exact dates because it was ongoing in every instance, but
Is there an allegation that it was ongoing?
Joint Appendix, page 10, paragraph 28 discusses, so Ms. Farrington alleges that the outstanding debt was caused by the financial hardship attributable to the defendant's discriminatory actions and defendant's ongoing failure to comply with the AJ's or the EEOC's order. So
they had paid her a substantial amount.
yes, that is
How much was it?
I believe it was $410,000 in back pay and a smaller sum in compensatory damages.
And she's alleging that she has a major credit card debt, notwithstanding having received the bulk of the award.
Yes, that is correct. And I don't believe that it's outlined specifically in the complaint in maybe as much detail as it could have or should have been. But that back pay award was disputed from the very beginning. So that money was not ever touched by Ms. Farrington. So it's really, yes, it
So it
is,
was received, but she chose not to.
because it was in dispute. I believe it was the advice of her counsel not to touch the money until the dispute was resolved. And that dispute has not yet been
They
dissolved.
weren't claiming that it was going to be clawed back. They were claiming that they didn't know her anymore, and she was claiming that they did.
In a subsequent proceeding, they did actually argue that that they did overpay her and that she owed approximately $100,000. So the debate of what she owed and what she may have owed back to the agency was in progress and really never fully resolved up until present date.
To get back to Judge Garcia's question, where did you say in the complaint that we are engaged in protected activity? I mean, saying that I have a debt that's caused by a failure to comply with a prior order. How does that tell the district court that I'm still engaged in protected activity?
So it's less so engagement in protected activity, more so opposition to the discrimination. So in that sentence that I cited to Judge Garcia on paragraph 28 of the complaint, she talks about the ongoing failure and her efforts to get the EEOC to comply with the order. So no, she did not necessarily engage in protected activity aside from the 2 EEO complaints, but she consistently opposed the debt as it related to the underlying discrimination that occurred.
But we don't have any timing on paragraph 28, nor who the explaining was directed at. I had actually originally, yeah, so as explained by Ms. Farrington and her attorney, the outstanding debt was caused by the financial hardships directly attributable to defendant's discriminatory action, defendant's ongoing failure to comply with the AJ order, as well as the unfair and unlawful predatory lending practices. Is there any allegation that FEMA was told that was her view?
No, there are no other allegations in the complaint, no.
Does that even allege that she told FEMA, this is why I have this big debt?
I believe that is alleged in the next paragraph.
I think it's sort of undermined by the next paragraph. Her explanations are supported by her credit report, but, oh, this was visible to defendant's personnel security officer. She's saying that the credit report showed the defendants, but it doesn't show the reasons that she's asserting.
Right, and that is accurate. Those are the few sentences that bear upon the issue that we are discussing.
Just to probe this a little bit more. So her view is that this is enmeshed with the past discriminatory action on FEMA's part and her opposition to it, because it is her view that the reason she's in such deep debt is that the prior case has not really been resolved, and that she is complaining that the prior case has not been satisfactorily resolved, and therefore that's her opposition to the defendant's unlawful conduct, and that is the locus of their retaliation against her?
Yes, that is correct. Her, the overall arching theme that she presents is that this is a coordinated, concurrent act that, you can't really separate the two. Everything started with this first EEO complaint in 2005 that led to her being demoted, led to her being in a financial state that incurred such debt throughout the, decade and a half that followed. She worked with several attorneys. She worked with FEMA to get that issue resolved, and it never
And
truly
is there an
was.
allegation that when Ms. Farrington obtained a favorable resolution of her dispute with Chase, that she communicated that to FEMA, basically saying, you know, they were wrong, I was right, and that's been resolved.
I believe that was communicated in her appeal of the termination that came in 2015. She explained the debt's been resolved. This is the reason for the debt. And again, reiterated her discriminatory allegations through that written appeal. But that was obviously after the decision had been made to terminate her employment.
So to the extent, I guess I'm just trying to understand, to the extent that and I take you to acknowledge that it's legitimate for FEMA to have the credit check, that is otherwise a legitimate non-discriminatory criterion.
Sure.
And that she didn't meet it at the time when they're reviewing her
Yeah, and
eligibility.
yeah, that's correct. And on the report that FEMA was able to see, it said that it was in dispute. So they had they have the right, sure, to conduct this background check as part of their standard business practices. That they were aware, though, that this was a debt that was in dispute, and it wasn't just that she went and put her hands up and let them figure it out. She did communicate, this is why I'm in this debt. This is why, you know, maybe, perhaps, you know, hindsight is 2020. She could have been more explicit at the time, but looking, you know, from where we are today, what you described is accurate in terms of the time frame.
And there's nothing alleging that she told them that because what she'd already been paid was still in dispute, that she didn't feel free to spend it. And it just,
I don't
think about
believe-
what they did know. Okay, we've given you a few $100,000 over a short period of time that's gone to zero, and you have this debt. And yeah, you're saying it's the bank's fault, but how often do people prevail against the bank? As it happens, she prevailed against the bank. And as it happened, you give an explanation why, notwithstanding that she had a large sum of money, that she's nonetheless running a major debt. But I didn't see allegations that they knew that.
I think that's correct. I don't know that she communicated her plan not to spend the money that was given to her. However, it's been subject to, I want to say, a dozen litigations over the course of the last 10 years in district court. So maybe at that moment, they were not aware of what the plan was in terms of the money, but certainly within a year, litigation ensued, and it became clear that that money was very much in dispute.
So in your opening brief, you framed a version of this as that the FEMA stated reason for firing her was pretextual. The government pointed out you didn't raise that type of argument below, and you didn't respond to this point in the reply brief. So I just wanted to ask if do you have any dispute with the government's position that you forfeited this, or are you otherwise abandoning that version of the argument?
Certainly. So we did raise that in the opposition brief at the district court level. It's cited in the Joint Appendix 101, 102. The district court cites the 3 additional arguments that we make to pretext and lists those 3 arguments. So we are not forfeiting those arguments. In fact, I think the pretext argument is stronger than maybe the temporal proximity argument, and the fact that the agency did not terminate Ms. Farrington for 2 years after she was found to be unfit for service. They could have, maybe they should have terminated her as soon as they got that fitness, the negative suitability determination, but they waited 2 years. So that begs the question as to, did they reasonably believe that just because Ms. Farrington had that debt, that she was unfit for service? That, I think that's a question of that goes to pretext and that goes to credibility. However, to your point, in the briefs before your honors, temporal proximity was was the large focus of the arguments.
I heard you to say that the district court thought you had made an argument based on the delay, the 2.5-year delay in firing her based on the fitness determination.
Yes, that's correct. And it's in the amended complaint of paragraph 37 and 37, 40.
Yes, I'm asking about, I didn't see it in your opposition to the motion to dismiss, and I didn't see it in the district court opinion. So you were directing me to 101 and 102. And I don't see them addressing this argument. The district.
Sure. So it's at the bottom of 101 into 102, where the district court goes into the 3 arguments that were raised on pretext. I mean, I will say it's not a lengthy analysis by either the district court or by Ms. Farrington in the lower court. But we did preserve those arguments and think that there are some merit to them that would warrant the case to move forward to discovery if your honors would reverse and remand the district court decision. Thank you.
Right. Here for Mr. Walker.
Good morning, Your Honors. May it please the court, Johnny Walker for the Secretary of Homeland Security. The district court correctly dismissed Ms. Farrington's retaliation claim because her complaint draws no causal connection between the protected activity that she began in 2005 and her eventual termination a decade later in 2015. She acknowledges in her complaint that a routine background investigation uncovered that she had $65,000 in delinquent debt to her mortgage lender, and that this led to a determination by FEMA's personnel security staff that she was not suited to continued federal service. She provides no plausible allegations that would indicate that her later termination was anything but the necessary consequence of that unsuitability determination. For that reason, she has not established the causal connection between protected activity and an adverse employment action that this court's case law requires, and the district court's order dismissing this case should be affirmed. I'm happy to answer any questions the court may have.
I mean, isn't it readily apparent that she was challenging and that there was even other litigation involving whether FEMA had complied with the prior relief that she had obtained?
There was certainly ongoing litigation dating back to 2005 that continues to this day in a case in the district court over that initial 2005 discrimination complaint. But what she does not allege is any particular protected activity by her during the course of that event that was proximate in cause to the adverse employment action.
But isn't that, I mean, she's opposing an unlawful employment action and she's continuing to oppose it because she's saying it hasn't been fully remedied. And I guess it seems a little semantic to say, well, she's not opposing any unlawful employment action. She got an award and she's saying, you know, to her, in her view, it hasn't been fully remedied. So that is ongoing opposition to an not yet fully remedied unlawful employment action, no?
It is certainly ongoing opposition, but there's no temporal proximity to a specific act that would give rise to an inference of retaliation. So what this court looks at—
temporal proximity to her then being fired.
The being terminated needs to be temporally proximate to some particular protected activity.
Ongoing opposition to the agency's failure to, in her view, fully remedy the established unlawful conduct of the agency in the past.
But what this court's cases look at is temporal proximity to some particular action by the individual,
Or
such that there
not
could
some
be—
ongoing action?
No, not some ongoing action. It doesn't have to be the initial discrimination
So
complaint.
what if it's, you know, somebody is harassing someone over a period of time? I mean, that's ongoing. And the fact that it began more than 10 years ago wouldn't mean that there's no temporal proximity.
Well, it would have to be temporal proximity to some particular oppositional or otherwise protected action.
And you don't think that maintaining a claim is a particular opposition?
No, Your Honor, and that's not what the cases look at. If you take a look at this court's recent decision in Ho versus Garland, I mean, there was ongoing litigation there, and the court drew temporal proximity to the filing of an actual formal discrimination complaint. And I think there's very good reason for that, because when you have this ongoing decade-long course of background litigation and the agency takes no action for a decade and then terminates her a decade after that has been ongoing for 10 years, the opposite inference has to be drawn, that there is some other cause that gave rise to that termination other than the ongoing background litigation that's been.
I appreciate your suggestion that an opposite inference needs to be drawn. It's an opposite inference might be permissible by a fact finder, but it's hard for us sitting here to say which inference in this complicated, thorny, ongoing, contentious relationship, which inference to draw.
Well, I think you have to think about sort of like the underlying reasons why the court draws an inference from temporal proximity. And the reason is because a supervisor becomes aware of protected activity and then suddenly takes an action within a very short period of time. This court generally says within 3 or 4 months. It's inconsistent with the supervisor's prior actions. And so there, when you have that kind of temporal proximity, there's a reasonable inference that can be drawn that that new knowledge was the basis for the new course of activity. Here you have ongoing litigation that's been in place for over a decade. There's no reason that these personnel security staff members and HR staff members suddenly gain knowledge of this at the time that they took the actions. In fact, the only allegations about knowledge that Ms. Farrington alleges is that these individuals may have known about this because FEMA was required to post it throughout its offices after she obtained her award back in 2008. So there's no sort of like sudden change in circumstance or sudden gaining in knowledge that this
For how you think this should work, if it said, hypothetically, at about this time, Ms. Farrington filed an opposition to motion for summary judgment, and then the supervisor became aware of that, and then maybe you could measure temporal proximity from that. Is that what you're saying? We need some kind of specific protected activity allegation?
Yeah, it could be. I think you need some kind of specific protected activity allegation. The fact that there's just ongoing background litigation, I mean, then the 2 or 3 month benchmark really means nothing, right? Because she's engaging in litigation over the course of a decade. There's always going to be the 2 or 3 month, but there has to be an event followed closely by an adverse personnel action.
Kind of counter to the old adage that revenge is a dish best served cold.
Exactly. I think so. I mean, that's the opposite notion of that is precisely what the temporal proximity inference is built upon, I think. The fact that there's a change in circumstance, that there's a knowledge of protected activity and then followed closely by a change in circumstance. Here, as alleged, there's knowledge dating back to 2008 and no change in circumstance until 2013 when she's deemed unsuitable, and 2015 when she's removed.
What about that 2-year gap? It's a little hard to understand. Ms. Farrington argues that the adverse fitness determination is seized upon as a pretext to terminate her. If they really cared about it, they would have done it earlier. What about the 2-year gap?
I don't think that, I understand 2 years seems like a long time. It's not such a long time when it comes to federal personnel actions. She certainly hasn't alleged anything indicating that the amount of time that it took was atypical or delayed for any improper purpose. And again, I think that the only inference that can be drawn from the amount of time that the agency took to finalize its action is that this was not being used as pretext, that the delinquent debt was not being used as pretext to terminate Ms. Farrington, because that amount of time just gave her additional time in which to resolve her debt and bring that to the agency's attention.
So why is that? I mean, it's the exact same amount of time since her undisputed last protected activity, which is 2012. And you're saying it's plausible that her argument is the fact you waited 2.5 years means you didn't really believe in the reason you gave. No one actually cared about this lack of fitness determination. And there seems like there's something to that. Why would you let this person continue having access to government systems, et cetera, for 2.5 years? Why isn't that a plausible interpretation of what's going on?
But, well, again, because she has not alleged anything that would indicate that the amount of time was atypical or otherwise delayed for any improper purpose. As we note in our brief, she doesn't allege, she is a temporary employee with FEMA. She's a reservist. So she is deployed to various disaster situations when the need arises. And as we note that she has not alleged that she was actually deployed by FEMA between the time that she got the initial letter of concern, or I think she did between the letter of concern and the actual unsuitability determination. But after the unsuitability determination, there's no allegation that she actually deployed for FEMA during the period of time between then and her
So
termination.
she wasn't actually, in the ways that we would think of like going to work or having access to a FEMA credit card, she wasn't actually in a position to use the FEMA credit card, or?
I think she does allege that she received a FEMA credit card. Her creditworthiness is a completely different inquiry from her suitability. That the government doesn't extend the line of credit. So whether or not the contractor that the government uses to provide government credit cards saw fit to extend a line of credit to her is a completely different inquiry from whether or not she is, the delinquent debt allows her to remain suitable for federal employment. I guess she does not dispute that a delinquent debt is a factor in suitability to federal employment. She does not dispute that her debt was well over FEMA's debt threshold, and she does not dispute that that type of unsuitability determination is grounds for removal.
She does, I think she alleges that she participated in some paid trainings between the time of the unsuitability determination and the time that she was formally terminated. Is that, how can we not see that as supporting her notion that FEMA wasn't really alarmed by this?
Because I think participating
Wasn't taking unsuitability that serious.
Again, the real reason that the delay is not grounds for FEMA not taking it seriously is because she has not alleged that it was atypical. But in addition, I think that participating in some paid trainings, getting paid to do a remote training or something like that for FEMA is completely different in kind from being deployed and holding yourself out as a federal employee. The suitability determinations are to ensure that the public views its federal employees as possessing integrity, being efficient, and so allowing her to do a training would not necessarily.
Why would we think 2.5 years is typical? I mean, literally what happened here is a new supervisor came in and maybe she was doing everything right, but it took her 4 months to discharge her based on this lack of fitness finding.
Yes, but there's no allegation that the new supervisor, and that's where I understand her argument about the delay to really come into play, is that it shows that she was terminated at the first opportunity by this new supervisor, but she doesn't allege anything indicating that that new supervisor was the impetus for the termination, or that the new supervisor would have any reason to be possess retaliatory animus against her. Certainly the supervisor was not involved in any way or implicated in any way in the prior protected activity from 2005, over a decade ago. In fact, she alleges exactly the opposite. She alleges that a representative from the Human Resources Department named Ms. Silva contacted her supervisor and advised her that she needed to terminate Ms. Farrington immediately due to the unsuitability determination.
Why is it that this litigation, the underlying litigation, has been continuing for so long? 2008, there's an order that can't be resolved?
I'm thankfully to report that in the last status report, the parties have reported that they have finally resolved their dispute about the back pay. There's some additional details to work out, but the reason that it lasted so long, I think, is that there was some remands to the EEOC to clarify some of its orders. So you had a whole another round of administrative proceedings that took place after that, and then the parties went back to district court after that. But that is a long litigation. The government is happy to see it coming to a close. Thank you very much. Please affirm.
Does Ms. Lees have any rebuttal time? We'll give you 2 minutes.
Thank you, Your Honors, and I'll just touch upon a few points. First is in regards to the 2-year period. I do think that is very crucial, or 2.5-year period. I think, Judge, I think one of you were referring to Joint Appendix page 11, paragraph 34, and that sort of describes that 2.5-year period where Ms. Farrington was receiving requests, for deployment, regardless of whether she actually did deploy, participating in trainings, and was listed as available for deployments in the agency's system. So, in my experience in the federal sector, as soon as someone becomes found to be unsuitable for federal government employment, typically the removal action happens relatively quickly. So the 2.5-year period is something that we think is extremely relevant for the court to consider. A second point is the fact that there was a new supervisor who did act at the first opportunity within 4.5 months of becoming her supervisor. And I just want to point out that we have now discussed temporal proximity. We have discussed that the proffered reason is unworthy of belief. We have discussed the supervisor change in first opportunity to retaliate. So all of these, we've discussed the knowledge that all of these agency officials have had of her ongoing EEO activity. So based on all of those factors, either taken separately or better taken as a whole, we believe that Ms. Farrington has alleged more than sufficient facts to withstand the motion to dismiss stage and allow her case to move forward to discovery to really flesh out some of the factual questions that still remain in dispute. Thank you.
Case is submitted. We'll take a 5-minute break.
The honorable court will now take a brief recess. please. This honorable court is again in session. Be seated, please. Case number 23-5251. Ammar Al-Baluchi, also known as Ali Abdul Aziz Ali, appellant, versus Lloyd J. Austin III, Secretary of Defense et al. Ms. Pradhan for the appellant, Mr. Schultz for the appellees.
Morning.
Good morning, Your Honors, and may it please the court. My name is Alka Pradhan. I'm here to represent Ammar Al-Baluchi, case of Al-Baluchi versus Austin.
Your voice is very quiet. It would help if you would speak up a little bit.
Of course. Is that a little bit better?
That's better.
Okay,
Thank you.
of course. Mr. Al-Baluchi is a torture victim who's been detained at Guantanamo Bay since 2006. His brain is damaged, and he suffers from a progressing spinal tumor, among other complex conditions. Regarding the central questions in this case, we're asking the court to find that the Secretary of the Army does not have the authority to unilaterally change a multi-service regulation like AR 190-8. And we ask the court to reconfirm the AR 190-8 from its plain language and from nearly every interpretation of the regulation by both the government and by courts supports Mr. Al-Baluchi's right to a mixed medical commission under the regulation. Beginning with the Secretary of the Army's memo, with regard specifically
Should
to—
probably begin with jurisdiction. because
Certainly.
it's, in question here.
Certainly, Your Honor. So the issue of jurisdiction is, what we're saying is that the denial of the mixed medical commission by the district court had the practical effect of denying an injunctive relief because of the irreparable harm to Mr. Al-Baluchi that can only be effectively challenged by immediate appeal under 1292A1.
What exactly is the irreparable harm that would be remedied if we heard your appeal and ruled for you?
Sure. So this case essentially inverts this court's denial of the government's appeal in the Katani case in September 2020. And there are several factors contributing to irreparable harm here. The first, I recall in Boumediene, the Supreme Court saying that the cost of delay can no longer be borne by those who are held in custody. And that is the case for Mr. Al-Baluchi here. He has been in custody without trial for nearly 22 years. He has serious documented medical conditions that are contained in 4 expert reports that we've submitted and in the DOD medical records that we've submitted. And those are in the Joint Appendix 183 to 223 and 293 to 324. And different from the Katani case, Mr. Al-Baluchi has had his habeas proceedings suspended at the district court since 2019, pending a final outcome from his military commission proceedings at Guantanamo Bay. And so this particular issue of the mixed medical commission, this is a final order on the mixed medical commission issue, as opposed to his habeas writ large. And there is no opportunity for this particular finding by the district court to be reviewed until the end, potentially the end.
It just seems like to get jurisdiction in the district court, you have to say you're not seeking an injunction because you don't have jurisdiction in the district court for injunctive relief. And then you turn around here to get us to give you grant jurisdiction of an interlocutory or collateral order. You say, well, this is really just like an injunction.
Well, Your Honor, there's a little bit more nuance than that. And we believe the government in their brief took our statement at the district court a little bit out of context. We argued below that we weren't seeking injunctive release in the habeas case itself, because the government was arguing that the request for a mixed medical commission was functioning as a request for a permanent injunction on his habeas case writ large. The request for a mixed medical commission is different. It seeks immediate specific action under the Army regulation. And regardless of labels, the practical effect test, which is what we're relying on here for jurisdiction, focuses on substance. Denying the mixed medical commission had the same effect as denying injunctive relief. And it foreclosed medical evaluation. It caused irreparable harm in the manner that I've just described. And I'm happy to talk about that in more detail.
But I guess just to get down to brass tacks, I'm
Sure.
it's very much kind of like a realist.
Yes, sir.
The mixed medical commission does not, those doctors aren't treating your client. So to the extent that there's any damage or injury or treatment that he's not receiving, they're not going to give that to him. So what is how is he, make it plain for me how he is irreparably harmed if he does not get this mixed medical commission review right now, as opposed to after the proceedings have completed.
Sure. I have 2 points for that, Judge Wilkins. Speaking practically, although the United States itself has not convened mixed medical commissions previously, mixed medical commissions are something that have been convened under international law in several different armed conflicts. And the practical reality of a mixed medical commission is that because they are convened by 3 physicians, those physicians there are actually 3 possible outcomes of a mixed medical commission. The first is that they can decide that the status quo is fine, this person is fit to remain detained, no notes. The second is that they can find that the person is currently fit to remain detained, but that they may have, as Mr. Al-Baluchi does, serious medical conditions that require perhaps some adjustments or require some treatment. And third, they can order release. And that is the way in which medical commissions have, in fact, functioned when convened by the RCRC. So that's the first note, is that, yes, they are not directly treating Mr. Al-Baluchi, but the findings of the Mixed Medical Commission do bind the U.S. government under AR.
They can't order release. They can't, under the Army regulation, they can't, Mixed Medical Commission can't say, let him out of Guantanamo today. And the Army has to let him out of Guantanamo today.
Well, first of all, it would be the Joint Task Force at Guantanamo that would that is ultimately in charge of detaining him, not the Army per se. But with regards to the provisions of AR 190-8, the findings of the Mixed Medical Commission, if they were to order the release of Mr. Al-Baluchi, they can in fact order that he is no longer fit to remain detained. And that finding does bind the government to carry out his release within 3 months.
I believe the government points out that at least in Article 115 of the convention, it seems to say, no, actually it is only binding, is required to be carried out once the military commission proceedings conclude. And that's the one issue I'd love to hear your response to.
Certainly, Your Honor. And, the government includes this as sort of a non-legal non sequitur. It is actually, I hesitate to say this, but it is actually patently untrue that that is what Article 115.1 says. The government cites Article 115.1 and then cites the ICRC commentary on that article. And the ICRC commentary makes clear the very opposite, and that's at page 4398 to 4399 of the ICRC commentary. I'd be happy to submit it in a 28-J letter. It says, and I quote,
Is that in the supplement or no?
"It is not, Your Honor."
What is the page site?
Page site is 4398 to 4399 of the ICRC commentaries, specifically on Article 115.1. And it says, and I quote, "Article 115.1 does not permit wounded and sick prisoners to be kept back on the plea that they are undergoing disciplinary punishment. They must also be examined by a mixed medical commission if they are so entitled, and the detaining power must carry out the MMC decision within 3 months, even if entire disciplinary punishment cannot be executed." So the Geneva Conventions make very clear the prioritization of medical care of detainees over prosecution and, in fact, serving of sentences. And this is in keeping with the overall point of the Geneva Conventions, which is to ensure the safety and security of detainees, of all detainees under international law.
The commentary that I'm looking at says it's Article 115, 4402, the repatriation or accommodation in a neutral country of convicted and detained prisoners of war who are wounded or sick is conditioned on the consent of the detaining power. Accordingly, the detaining power may keep the prisoner of war detained for the duration of the judicial proceedings or until they have served their sentences. Is that not applicable?
No, Your Honor, and I think, well, it's not that it's not applicable, it's that when you put it against the commentary on Article 115, it makes clear that the prioritization is for medical care. So yes, generally, of course, the detaining power can make a decision with regards to the wounded and sick and how sick they are. But once they are seen by a mixed medical commission, and if a mixed medical commission recommends release, it is not up to the detaining power to determine how long to hold them.
Well, it talks about, I guess it's talking about the repatriation of people who are wounded or sick and saying that it's conditioned on the consent of the detaining power. And you're saying that's not referring to someone who's wounded or sick and been held to be eligible for repatriation by a mixed medical commission?
So again, I don't think that these two provisions are necessarily in tension, but I think that when there is a tipping point, and what this says specifically is, yes, the detaining power has discretion as to when the wounded and sick can be repatriated, but there's a tipping point, and that's what the commentary in Article 115.1 refers to, which is it does not permit those detainees or those prisoners to be kept back just because they're undergoing disciplinary punishment or undergoing prosecution. And then with regards to the mixed medical commission provision, it specifically prohibits the detaining power to allow them to continue to serve their sentence.
So you're referring to commentary on Article 115.1?
Yes, Your Honor.
And I think the government is referring to the commentary in Article 115.2, which is 115.1 is about disciplinary punishment, and 115.2 is about treatment in connection with a judicial prosecution.
Mm-hmm.
So isn't this more a judicial prosecution than disciplinary punishment?
Well, at the moment, it's we're not really sure what it is, to be perfectly honest, because Mr. Al-Baluchi, again, is being held without trial for nearly 22 years. So there is a judicial process ongoing, but the overall point really is that the Geneva Conventions specifically contemplate a possible tension between the need for medical care and the need for repatriation and a continued judicial proceeding or a continued serving of sentence, and prioritizes the need for medical care.
Are you talking about under 115.2 that it's prioritized the need for repatriation? Because it seems to me explicitly to say that they could be repatriated only if the detaining power consents. And then the commentary says that it's the prerogative of the detaining power to keep a prisoner of war detained for the duration.
Yes, Your Honor, but the fact that included in the commentary on Article 115.1 is the specific provision for a mixed medical commission to examine these prisoners despite any ongoing
Disciplinary proceeding in that.
Disciplinary proceeding, but despite that, specifically contemplates the possibility that medical care may have to circumvent any prosecution or judicial proceedings regarding these detainees.
So what is the practical effective injunction? What is the irreparable harm that in order to convene a mixed military commission would redress?
So Mr. Al-Baluchi seeks an independent evaluation of his medical conditions by the government. And the key is that this provision, Section 312 of AR 190-8, is binding on the government. He has had a number of independent experts examine him, and the court has those, the court has those reports in front of it indicating that he has serious medical conditions. And those are bolstered by the DOD medical records on But the point is, none of those are actually binding in terms of what the government has to do about it. So Section 312 provides that sort of binding procedure by which he can get an evaluation that says, yes, he's fit to stay detained. Yes, he's fit to stay detained, but requires, this sort of treatment, which is the way in which mixed medical commissions have been carried out in the past. Or actually, he's not fit to continue treatment. He's got a spinal tumor that may require surgery, and he needs to be repatriated or sent somewhere where he can get that care.
So assuming that we agreed with you that there's jurisdiction here, in terms of the relief, I gather that that the argument is really the crux of it is under Army Regulation 190-8. And I guess my question is, are you arguing that your client is entitled to a mixed military commission under the Geneva Convention itself, or is it under AR 190-8?
It's under AR 190-8. And the argument is that it's by its plain language, and also, and this is the part that that requires some history, by the government's own application of AR 190-8. So for example, the detention memorandum that was filed in 2009, that the government initially filed in Mr. Al-Baluchi's habeas case, which I apologize is not part of the record, and I'm happy to submit it, states explicitly that principles derived from international armed conflict must inform the interpretation of detention authority over the current conflict. So you have the government arguing in 2009 that in fact we have to import principles of international armed conflict to this new conflict against a non-state actor, against Al-Qaeda and associated forces. Following that memo and echoing the government's
Why is what you just said in any tension with the government's position that he is entitled to Article 3 type minimum protections, but not the elevated protections of prisoner of war status?
Because Judge Garcia, following that memo and in accordance with the government's previously stated position in the Hamdi case in 2004, the government argued for the application of Article 5 status determinations via implementation of AR 190-8 to Guantanamo detainees in the Al-Bihani case before this court, and in their opposition to cert before the Supreme Court in the Al-Warafi case. This court agreed in Ammar that AR 190-8 was the applicable domestic law to Guantanamo Bay. And so it is our position that Mr. Al-Baluchi the government's position is that Mr. Al-Baluchi is an alien, unprivileged enemy belligerent. And it is the longstanding position of courts and the government that the designation or title of AUEB or enemy combatant, as Judge Collier reasoned in the Katani case, does not strip Mr. Al-Baluchi or any Guantanamo detainees of the categorization of other detainee, which very plainly on its face applies to them, of AR 190-8. Now, other detainees are entitled to the provisions available to enemy prisoners of war under that regulation.
Well, Judge Collier so held in Katani reading this rule, but you have not referred us to anywhere where the government took that position.
The government's position is that Article 5 status determinations as implemented in AR 190-8 are applicable and have been applicable to Guantanamo detainees. And so, for example, in the Al-Bihani case, they specifically quoted AR 190-8 and said Article 5 status determinations and footnote AR 190-8 for that. And that is in keeping, again, with their view that principles of international armed conflict must be applicable.
I'm not sure that I'm meshing this with what I read in your briefs.
Sure.
I thought you were arguing that AR 198 entitles your client to a mixed military commission because, in your view, he qualifies as an other detainee,
Yes,
not
Your Honor.
because he qualifies as a UEB or that a UEB is necessarily treated as equivalent to an enemy prisoner of war. Is that right?
That's correct, Your Honor, and I apologize if I've not been clear enough. So following Judge Collier's reasoning in Katani was a little bit different. He was categorized as an enemy combatant. That was his title. The reasoning, however, is exactly the same in that both enemy combatant and AUEB fall outside of the categorizations in AR 190-8. So under in the glossary of AR 190-8, the category of other detainee is applied to anyone who does not fall in the other three categories specifically delineated in AR 190-8.
Can
And
I
so
ask, are you disputing that the character of the conflict pursuant to which Mr. Al-Baluchi was detained is non-international?
no, not at all.
So you are accepting that it is from a non-international conflict?
We accept that it's a non-international armed conflict. The other source but however, just to follow the reasoning as to why Mr. Al-Baluchi falls under AR 190-8, because the category of AUEB is an other detainee, falls into that catch-all under the glossary of AR 190-8. Other detainees are specifically under Section 1.6 of AR 190-8 afforded the same rights that are given to enemy prisoners of war.
I'm sorry to stop you, but I thought I just heard you say that the glossary defines a UEB as an other detainee.
No, Your Honor.
No, it doesn't.
No, it doesn't. No.
Right. It
because
just says that the other detainee, and that, I understand that to be, so assuming that we treat the regulation as applying to non-international armed conflicts, it by its terms is restricted to certain EPWs and RPs, and your argument is that your client should provisionally be treated as an enemy prisoner of war, right? You're not arguing that he's a retained personnel or a civilian internee.
No, Your Honor.
Or even an enemy prisoner of war, but that he should be treated provisionally as an enemy prisoner of war pending any status determination.
That's correct. And the reason for that, again, is going back to the government's own argument that Article 5 status determinations that are normally found in international armed conflict are and have been long applicable to Guantanamo Bay detainees. And the bookend
But so
between,
if somebody were a retained personnel, they were a medic, and they were at Guantanamo, that would assist them. But here, there's no claim that your client is a medic, for example, or a cleric.
No, Your Honor.
So if it were determined, and I understand that you have some questions about the authority behind the determination, but if it had been determined that your client's status is unprivileged enemy belligerent, that's the end of your argument, right? Because if he's so determined, that is in contradistinction to an enemy prisoner of war. An unprivileged enemy belligerent is someone who is not fighting on behalf of a nation state and the other requirements of insignia and whatever. So the provisional grant of enemy prisoner of war status would no longer be applicable because it would be clear that he's not an enemy prisoner of war.
No, Your Honor, for a couple of reasons. This court in Ammar II found that the mere designation of enemy combatant, which is another designation that falls outside of AR 190-8, does not render AR 190-8 inapplicable. Again, for the purpose of application of the regulation to Guantanamo detainees. And then Judge Collier followed that reasoning. We believe that Judge Collier got it right in saying that, look, enemy combatancy or AUEB or any other designation that falls outside of AR 190-8, and I'll quote Judge Collier, she said, he remains an other detainee because the descriptor is not found in AR 190-8. He remains an other detainee for the purposes of the regulation and is, by its terms, entitled to rights available to EPWs, including the MMC. Now, I just want to note that this determination about status turns on the application of Article 5 of the Geneva Conventions, which are generally available during international armed conflicts. And so taking the government's statement in their memo of 2009 that principles of IACS must be applicable to Guantanamo, and the 2023 version of the DoD Law Form Manual, which the government states is the DoD's authoritative statement on the law of war. That manual states at section 427.4 that Article 5 status determinations, while usually applicable in international armed conflicts, have been used by the Department of Defense and are used by the Department of Defense in additional situations. And they list a number of situations and specifically list Guantanamo Bay. And so you have, and this July 2023 Law of War Manual postdates the Secretary of the Army's memo. And so you sort of have these parallel tracks where you have one government agent issuing this unilateral memo in January 2021 saying very suddenly and contrary to all previous briefing by the government and court statements that now AR 190-8 does not apply to non-international armed conflicts, where their DoD Law of War Manual says the opposite, and their previous detention memorandums have even argued the opposite.
So your argument is that the applicability of AR 190-8 to Guantanamo means that it doesn't matter whether there's a status determination that's in contradistinction to enemy prisoner of war, because as a policy matter, the government has chosen to treat a UEB, unprivileged enemy belligerent, as if he were an enemy prisoner of war?
Well, that is part of it, Your Honor.
That is you have to prevail on that to prevail in your case?
No, we believe that the plain language of AR 190-8 is not applicable only to international armed conflict, and that the category of other detainee is specifically included there to catch these any other determinations, right? And that's in keeping with the spirit of the Geneva Convention. So the government can name Mr. Al-Baluchi an enemy combatant. They can name him an AUEB. They can name him something else. We know that that designation has changed over time as well as the government's legal position on these detainees has changed over time. But the fact of the matter is they cannot write him or other detainees out of the applicability of AR 190-8. This court should not allow the government to use Article 5 status determinations when convenient to them to justify the holding of these detainees at Guantanamo Bay indefinitely, but then claim that it doesn't apply when it is inconvenient to them, when they then find a right to which they are entitled under AR 190-8.
So putting aside it seems like your strong argument in your view is the government's past positions, and I appreciate that. If we set that aside, just based on the text of 198, is there anything you would point to as showing that it's actually a departure from this distinction between non-international and international armed conflict?
Certainly, Your Honor. It's the AR 190-8 in its front matter states that it applies to armed conflicts and all military operations other than war. And
which doesn't exactly speak to international versus non-international. It could be speaking to military operations short of war.
yes, but it would lead to a legal absurdity, and it would be not in keeping with the Geneva Conventions, frankly, if the regulation that governs all detention operations by the United States applies only to international armed conflict and then only to military operations and perhaps what we call in international law security situations that do not rise to the level of armed conflict. It really leaves a very, very large gap there that is not supported by the text of AR 190-8. And again, as Judge Collier pointed out, the government points to no specific language in the regulation that supports their reading that it has to be limited to international armed conflict, because in fact, if you read the entirety of the regulation, it is written in very broad terms indeed, and has been taken by the government because of that plain language to apply to all manner of armed conflicts and outside of armed conflict where the military is engaged. I did just want...
As I read the government's position, it quite clearly says that an unprivileged enemy belligerent is not entitled to any of the distinct privileges of an enemy prisoner of war.
Yes, and this is where we see the contrast between the government's use of Article 5 status determinations derived from international armed conflict to be able to say look, this is how we're using these status determinations in order to find some designation that is outside of a category that we've ever used before. But then they say, no one else, you can't use these Article 5 status determinations to obtain rights to which you would normally be entitled under AR 190-8, given that you fall into the catch-all category of other detainees.
Can I ask, the government relies on the president's 2002 determination. Can you just explain your response to why that's
Certainly, it's very briefly. The president himself is not the proper, no one is impugning the authority of the president of the United States, obviously, but the Geneva Conventions are very specific on what constitutes a competent tribunal for the purpose of these status determinations, and it is not a determination by the president of the United States, which is inherently political.
There might be other problems with it, but you're relying on the regulation, and the regulation refers to competent authority, not a competent tribunal. So I'm not sure that distinction is sufficient.
But again, it's been the position of the government since Guantanamo Bay opened that principles of international armed conflict must inform the current conflict. And if we're going to import principles of international armed conflict, this is a pretty key place that they would be changing that principle in contravention of the actual purpose of that, which is to establish a competent tribunal that can assess the matter of status determination with some neutrality, as opposed to the president of the United States, which, whoever he or she may be, is not considered an entirely neutral party.
I'm reading the commentary to Article 5 saying that the task of establishing that a person is not entitled to prisoner of war status should rest with the detaining power, and that the procedural guarantees applicable to status determination proceedings are not regulated by international humanitarian law, but are a matter of domestic law or regulation. So I just don't see anything in the commentary or in the Geneva Convention itself that suggests that a determination by an entity of the detaining power, that the detaining power has authorized to make it, is not competent authority for this purpose.
Well, so there is language in the commentaries, and I can find the site, Your Honor, I apologize, I don't have it in front of me, about what a competent tribunal actually is. And I believe that we briefed it in our reply brief. But even aside from that, even if we were to accept that the president is a competent authority for making this determination, that means that he is or she is the competent authority for making a determination that the person is an AUEB for the purpose of detention. That, again, that still doesn't remove the AUEB or the enemy combatant from the protections of AR 190-8, which the government itself used to make the determination that that person should be held. If I may briefly address the memo of the Secretary of the Army. I'm happy to
briefly give it. Can you?
Yes, of course. So firstly, with regard specifically to Mr. Al-Baluchi, the district courts determined in the Katani case in March 2020 that, really affirmed the longstanding position that AR 190-8 was applicable domestic law to Guantanamo Bay detainees. Mr. Al-Baluchi made his request under the appropriate provision of AR 190-8 in May 2020. And the Army memo is not issued until January 2021, purporting to overturn a judicial finding that, in fact, AR 190-8 was applicable domestic law. And so, as a preliminary matter, we argue that it does not apply to Mr. Al-Baluchi at all. However, the district court reasoned that the Army Secretary, as the executive agent of the regulation, could therefore issue policy guidance for the regulation. It is true that the Army Secretary is the executive agent for the regulation, but multiple DoD directives make clear that the executive agent does not have the authority to develop, coordinate, and implement policy guidance for regulations. that power is reserved to the Undersecretary of Defense for Policy. The officials specifically designated under the DoD Directive 5101, which is not included in the government statutory addendum, to oversee the executive agent's execution or administration of the law. And this is important. It's a really important point because detention policy cannot be dictated unilaterally by even the head of a military department, the head of a single military department. Guantanamo is a joint task force detention operation. It's run on a naval base. The personnel, including the medical personnel, are from multiple services. And so the policy regarding detainees there and in any theater has to be coordinated properly through the USDP, particularly for a joint service regulation like AR 190-8 that was promulgated by the Secretaries of the Army, Navy, and Air Force. And again, where we find this to be a problem is you have this memo from the Secretary of the Army in January 2021, and then you have the DoD Law of War Manual, which is the authoritative statement of the DoD on the law of war in July 2023, saying specifically AR 190-8 is applicable at Guantanamo Bay. So this is why the coordination has to take place, and it did not take place. And so the Army memo should not be given any legal weight.
All right, we'll give you a limited amount of time for rebuttal, and we'll hear now from Mr. Schultz.
Thank you.
May it please the court, Benjamin Schultz on behalf of the government. This court can resolve the case on appellate jurisdiction for the simple reason that Mr. Al-Baluchi does not satisfy the irreparable injury test. And more specifically, he can't show that convening a mixed medical commission would remedy some sort of irreparable injury that requires immediate review. Put simply, that is because, as both the Geneva Conventions make clear, and as the DoD instructions that bind the Army and outrank the Army regulation that he relies on, if an individual is facing a judicial prosecution, as Mr. Al-Baluchi is before the military commissions, then any recommendation of the mixed medical commission, including one that would otherwise require repatriation, would not be able to be implemented until at least the completion of those judicial prosecutions.
Could be implemented. It wouldn't, the government could exercise a prerogative to wait, but it doesn't have to.
Your Honor, you're right that the government would have the option at its discretion, just like it has the option now, even without convening the mixed medical commission, to do something other than maintain the prosecution against Mr. Al-Baluchi.
Well, petitioner makes a persuasive argument that the mixed military commission's findings would inform the disposition of his case, could provide the impetus for Mr. Al-Baluchi's eventual transfer. So assuming that he, for purposes of jurisdiction, that he's entitled to the mixed military commission, isn't it fair to think that denying the relief he seeks does cause him irreparable harm?
Well, Your Honor, in order to reach that conclusion, Your Honor, would essentially have to be saying that the irreparable harm that needs remedying, that he needs immediate review now to get, is essentially some sort of advisory position from this mixed medical commission, giving their medical opinions that would not bind the government in any way. Now, if the court wants to say that this advisory commission from these three doctors saying whatever they think, and mostly it would be just saying about whether or not he's sick enough to get repatriation. I'm not really sure where she gets the additional stuff about additional treatment, because that's not in the Army regulation and that's not in the Geneva Convention itself. But even putting that aside, if this court wants to say that that advisory opinion is remedying some irreparable harm, I think that's a difficult position, but that would have to be the basis.
Right, it's meant as an independent medical judgment about the condition of it.
Your Honor, given that the test here is whether or not the district order has the practical effect of an injunction, it seems odd to think that something has the practical effect of an injunction when the only effect it has is giving some sort of advisory recommendation that nobody's bound to follow. So if the court wants to say that as a matter of its case law, that meets the practical effects test, and it really is an injunction, that would be something the court could say. We think that's wrong, and that's not what this court's case law seems to think. And
Is that the right way to think about what the injunction would be, or is it the injunction would be to convene the commission.
The injunction, I mean, again, we have to put ourselves in the world where he's disclaimed seeking an injunction because he has to fit himself into the universe where what he's seeking is habeas. But we're in this universe where somehow the district court enters an order that under this court's case law counts as a habeas writ, and that is in some way requiring the government to convene a mixed medical commission. But that is all that the order would be requiring. It wouldn't be requiring the government to follow any of the recommendations of the Mixed Medical Commission, except to the extent that if the Mixed Medical Commission recommends repatriation, that I suppose would become binding at the conclusion of military commission proceedings, unless he's convicted, in which case it would then become binding at the conclusion of the sentence, which, given that he faces a potential capital sentence, it's possible that the Mixed Medical Commission's recommendation would never be implemented, or he could also end up with a life sentence, in which case the Mixed Medical Commission's recommendations would never be implemented. So I'd be happy to spend more time on jurisdiction. Otherwise, I can briefly turn to the merits. And I think here there's a lot of different grounds that the court can rule on. It can do it based on the straightforward argument that AR 190-8 can't be inconsistent with the Geneva Conventions, and it's clear that in non-international armed conflicts, the only part of the Third Geneva Convention that would apply would be Article 3, and it would not be the parts about the Mixed Medical Commission. Or I think another basis that the court could go on would be the fact that in order to prevail, he has to show that he is an other detainee within the meaning of Army Regulation 190-8. And it's very clear that he is not, because to be an other detainee under 190-8, even if he otherwise would have an argument that maybe he's a prisoner of war, which he doesn't have, that provisional status would only apply until there is a determination by a competent authority. And as the court pointed out in the questioning of my opponent, there have been competent authorities that have determined that he is not entitled to prisoner of war status. And that would include the Combatant Status Review Tribunal, and that would also include the president. And either of those would be sufficient. Certainly both of those are sufficient. So again, I'd be happy to address that or any of the other issues in the case. I'm also happy to address the Army Secretary's memorandum if the court wants to talk about it.
The other detainee definition is a little bit odd.
Okay.
It says you're treated as an EPW until a legal status is ascertained by competent authority.
Correct.
And even if the president's determinations otherwise would apply, it's not, does it assign him a status? All it says is not a prisoner of war. It's not a status determination.
Well, respectfully,
I don't understand it.
Well, respectfully, I think the status, at a minimum, the status determination would be from the Combatant Status Review Tribunal, which determined that he was an unprivileged enemy belligerent. I believe they use the older term enemy combatant, which the DOD instructions say is
equivalent in your view?
that is what the DOD instructions say. I think we've cited those in our brief, that the two terms are interchangeable. So that is his status, and that is why he is not someone who could ever qualify for prisoner of war status.
I read you to have another argument that essentially, at least the bottom line was, because this is in connection with a non-international armed conflict, 198 is basically irrelevant.
You're right. That's another way that Your Honor could get there, that the 190-8 can't supersede the Geneva Conventions, and it's pellucid that the only thing in the Third Geneva Convention that applies in non-international armed conflict is Article 3. The Mixed Medical Commission is not contained in Article 3, and therefore it doesn't apply to him.
Well, that Article 3 is a floor, right? The United States certainly would have authority to go beyond it. I'm not sure if it went beyond it, that would be a conflict or discrepancy.
As a discretionary matter, I suppose it would be possible, but in order for Mr. Al-Baluchi to prevail, he has to show that it is required under domestic law that he be able to convene a Mixed Medical Commission.
And there are places where the United States has overtly said, we are going beyond that floor.
The Law of War Manual lists two specific examples. One is the fact that Guantanamo detainees have habeas rights, and the other is it gives a very narrow example during the Vietnam War of certain privileges accorded to guerrilla groups that were not engaged in terrorism. So Your Honor is right that it is possible to go beyond that, but whether the government in its discretion chooses to go beyond that is not sufficient for Mr. Al-Baluchi to prevail. He has to show that it's required under domestic law that the government convene the Mixed Medical Commission, and he can't show that.
That portion of the Law of War Manual it references some administrative process at Guantanamo Bay. Can you explain?
I'm not quite sure which part you're referring to. I think the part that
petitioner is citing about it's in footnote 544 maybe.
Sorry, I don't have the full manual. It's pretty heavy.
No, I'm certain you don't.
But I think the clearest statement is, if you go to 4.19.3.1, it says unprivileged belligerents are not entitled to the privileges of POW status, prisoner of war status. And we think that is about as clear as you can get.
Say it again.
So yeah, this is, we cite this on pages 31 to 32 of our brief. Law of War Manual says at 4.19.3.1, unprivileged belligerents are not entitled to the privileges of prisoner of war status. And the very next section, 4.19.3.2, it says during international armed conflict, in cases of doubt as to whether a person held as an unprivileged belligerent is in fact a POW or entitled to POW treatment, that person should enjoy POW protections until their status is assessed by its competent tribunal. So it's telling you two things. It's telling you, one, if you're an unprivileged belligerent, you don't get any of the things that you would get from either being a POW or being treated as a POW. And two, it's saying in international armed conflict, which this is not, you do get some sort of provisional status until you have a competent tribunal determining that you're not entitled to it.
And it accords with your view that the 190-8 other, the other detainees category tracks that in the sense that until it's been determined whether you're an enemy prisoner of war or retained personnel or civilian internee, you're treated as if you're a prisoner of war. But once it's been determined that you're something that is in contradistinction to a prisoner of war, then you no longer get that residual treatment.
I mean, that is one of our arguments, absolutely. Again, we think, as I explained to Judge Garcia, I think another way you could get there is you don't even need to get to 190-8 at all because this is a non-international armed conflict. But if you want to kind of assume that 190-8 might apply anyway, then under the clear terms of that other detainee language, whatever provisional status you might have gotten initially, you don't get it once you have a status determination, and we have that here.
On the broader argument that 190-8 just doesn't apply to non-international armed conflict, I think petitioners suggest that means there's no regulation out there that governs sort of Article 3 detainees from non-international armed conflicts. Could imagine a few responses, but I'd like to hear yours.
Sure. Well, one thing is that within the Department of Defense, there are various sources of law. Army regulations are one potential source of law. DOD instructions are another source of law. There are DOD instructions that govern aspects of detainee operations at Guantanamo Bay.
Including the DOD directive that's in the briefs here.
Correct.
We've established all-encompassing.
Correct. That's exactly right. There's a DOD directive that we cite about treatment of detainees. There's also DOD directives about healthcare, and we've cited those in our brief, and they reaffirm that the individuals at Guantanamo are entitled to healthcare, and the government acknowledges that. So I don't think it's
the argument. You're not saying there's anything affirmative in 198 that we could look at and say that says it doesn't apply in non-international armed conflict. It's more of the baseline is non-international armed conflict detainees do not get access to these kinds of rights. You'd expect to see something clearer in 198 if it was departing from that.
So I think the argument is 190-8 at the very beginning says that anything about 190-8 that's inconsistent with the Geneva Conventions take precedence. And because the Geneva Conventions are clear that in non-international armed conflicts, the only part of Third Geneva Convention that is applicable is Article 3 and not any of the other stuff, that's the part of 190-8 that you would look to know that we're not talking about non-international armed.
But it's really in conflict. I mean, if the United States wanted to apply that to non-international armed detainees in non-international armed conflicts, nothing in the Geneva Convention would forbid that.
Well, respectfully, it's not just conflict. It actually, if you look at the language in 1-1, it's broader than that. It says in the event of conflicts or discrepancies. So I think the preface to 190-8 is really telling you, we're not just trying to say like, don't conflict with the Geneva Convention. We're trying to really implement it here. And you got to read what we're doing here in light of that. I'd be happy to address any remaining questions that the court has. Otherwise, we would ask the court to affirm or rather dismiss for lack of jurisdiction and otherwise affirm.
I'm just seeing if there's anything else to ask. All right. Thank you.
Thank you.
So I believe that Ms. Pradhan used all her time, but we'll give you 2 minutes for rebuttal if you'd like it. You don't have to take it.
I would, Your Honor. I do just want to note that I did reserve 1 minute, but that's neither here nor there. So I don't want to let the government's misstatement of the DoD law form manual go by because this is extraordinarily important because it provides the bookend for the government's continuing employment of AR 190-8 when it is convenient to them. And so I'm not sure what my learned colleague was looking at, but at section 427.4 of the DoD law form manual, it states, it does acknowledge that Article 5 of the Third Geneva Convention addresses entitlement to POW status. And then it says, DoD practice has been to use Article 5 tribunals or similar administrative tribunals to address these issues. For example, DoD used administrative tribunals to address a variety of issues during detention operations in Vietnam, Panama, the Persian Gulf in 1991, Iraq in 2003, Afghanistan, and Guantanamo, which we all acknowledge is a non-international armed conflict. This is again in keeping with the government's longstanding position.
Can you say again what you're reading from?
Certainly, Your Honor. It's the DoD law form manual, which is called by both the government and the Secretary of the Army as the DoD's authoritative statement on the law form. And it is section 4.27.4 entitled Tribunals to Assess Other Detainee Issues. And footnote 538.
Not in your supplement, not in your addendum.
It's cited in our reply brief, Your Honor, and it does say that at footnote 538, it cites, interestingly, it doesn't say Army Regulation 190-8. It says 1997 Multi-Service Detention Regulation, which is perhaps a more accurate description of what the regulation actually is. And this is not, this is an extremely authoritative statement. The Secretary of the Army cites the law form manual as higher level guidance for interpretation of application of AR 190-8, even in the memorandum where he strips detainees of the protections of AR 190-8. The government acknowledges the supremacy of the DoD law form manual's statements on how the United States implements the Geneva Conventions at Guantanamo, specifically citing Guantanamo.
So I'm looking at this provision of the Law of War Manual, and it says, after saying Article 5 addresses entitlement to POW status, it says administrative process may be appropriate to address status questions besides entitlement to POW status. And I suppose the government might say, this is just explaining other ways that we have used similar looking administrative processes, but we're not agreeing that those were determining POW status, which is what you would need to be the case.
Well, yes and no. And the fact that they are citing AR 190-8, which they claim implements only international armed conflict concepts for this proposition, incorporates by reference that regulation to the following sentence where they say, for example, DoD uses such administrative tribunals to address detainee issues in, for example, Guantanamo Bay. So this is the current position of the Department of Defense, whereas government agents are here arguing because Mr. Al-Qahtani and Mr. Al-Baluchi asked for their rights under the same regulation, are now saying, well, no, this regulation is not applicable in non-international armed conflict, citing absolutely no language from the regulation that says that. Now, with regards to status, I do just want to note briefly that while we acknowledge that the government's view of Mr. Al-Baluchi is that he is an AUEB, our position is actually that he does not currently have a valid status determination, and this is in our briefs as well, that the CSERT determined that he was an AUEB, and we appealed that determination, and the government dropped that appeal. So there's no final status determination for Mr. Al-Baluchi, and which differs again from the Qahtani case where there was a final status determination. He accepted the designation of enemy combatant.
I don't understand how the government dropping an appeal, the determination, you were the one challenging the determination.
Yes, Your Honor.
So I don't understand how you're saying that that determination is not valid because the government dropped the appeal. You were the one challenging the determination.
Yes, Your Honor. And it is so, it goes to the fact that our position is that Mr. Al-Baluchi still does not have a valid status determination. And so it's simply one more factor on the scales of, first, even if he did have a determination of AUEB or enemy combatant, as I said earlier, that would still place him in the other detainee category under AR 190-8, because as this court said in Ammar 2, that designation does not render AR 190-8 inapplicable to these particular detainees.
I guess I'm just confused about your position. I mean, if you're saying that his determination by the combatant status review tribunal is invalid, then wouldn't that be grounds for his release?
Well, he is still being detained under the AUMF or, various detention authorities, but it's, so yes, certainly we could argue that, but for the purpose of this litigation, what we're saying is, first, if he is an AUEB, as the government has stated, he falls in the other detainee category, as Judge Collier reasoned below. But the fact that we have challenged that status, the fact that we don't believe that that status determination is final, places him even more into the other detainee category through which he should benefit from prisoner of war protections under AR 190-8.
Can I ask, and this goes to the question of appellate jurisdiction in determining whether your client's claim for entitlement to a mixed military commission, whether it's separate from the merits of the habeas claims in the underlying action, what are the arguments in the state habeas petition?
So his habeas proceedings have been stayed since 2019, pending the outcome of military commission proceedings. And so the only reason that the stay would be lifted is for issues that sound in habeas that cannot be addressed by the military commission or will not be addressed by the military commissions. And so Judge Friedman and other district judges have found that the requests for mixed medical commissions do sound in habeas, and so they do have jurisdiction over those issues. Now,
so I guess, but what I'm asking is, one of the questions, if we're looking at collateral order review, which is distinct from your argument under Carson, this has a practical effect of an injunction. But under the Cohen versus beneficial loan, the notion that you're entitled to interlocutory appeal because this is a collateral order, we would have to determine that the claim of entitlement to a mixed military commission is separate from the merits. And it sounds like it's not. It sounds like it's part of the underlying habeas.
No, Your Honor. And so under the collateral order doctrine, we believe that we fulfill all three conditions. First, this conclusively denied Mr. Al-Baluchi's right to a mixed medical commission. Second, it resolved his ability, or it purports to resolve his ability to access the mixed medical commission for evaluation, which is entirely separate from his habeas challenge. Now, the government—
Although I thought that it's part of the habeas challenge.
Well, it sounds in habeas, and this is one of the ways in which Guantanamo is a little bit of a different animal because of the conditions of confinement litigation falling under habeas for this purpose. But it is not. The merits of habeas are not coextensive with the merits of determining whether or not he has a right to a mixed medical commission. Now, that right has been cut off by the district court for now, and his habeas petition, meanwhile, remains pending. Now, the problem is, and this is what makes it unreviewable, is that we're looking at, it is no exaggeration to say, years, if not decades, before that habeas petition can be returned to. I'll give you some numbers. We are scheduled for pretrial hearings at the Military Commission through the end of 2025. All parties agree that a trial date, once set, if set, will take a minimum of 1.5 years. So that is an absolute minimum of 2.5 years before there is any verdict in the military commission proceedings. If it's a capital trial.
Right, I was only asking about this separate from
Certainly.
merit.
Certainly. So that's our position on the collateral order doctrine. The very last point, very briefly, that I would just make is with regards to the government's position on, whether this could be released. And I believe my learned opponent said that I'm not sure where she's getting the other possible outcomes of the Mixed Medical Commission from. And that's from practice. The mixed medical commissions that have been convened, both post-World War II and the ones that are actually being proposed right now with the support of the United States in Ukraine, are clear that the physicians of the Mixed Medical Commission can find that certain treatment or certain conditions may be necessary. And I want to just bring this back quickly to what the real point of this is for Mr. Al-Baluchi. At the heart of this is his need for healthcare, for his need for a medical evaluation. And I think the independent expert reports make that very, very clear. That's what we're talking about here. He has not been able to have an evaluation.
All right,
And
all
yes.
right. You can wrap up.
All right. All I want to say on that, Your Honors, is just that really the agony of having this right revoked at a time when he thought it would be possible to compel the government to at least order the evaluation cannot be overstated.
All right. Thank you. The case is submitted.
Tuesday, December 10th at 1:30 p.m.